Thank you. Well, welcome everyone to Portfolio Committee number 1, Premier and Finance's inquiry into the Electoral Funding Amendment Bill 2023. I'd like to start by acknowledging the Gadigal people of the Eora Nation, the traditional custodians of the land on which we are meeting today. I pay my respects to elders past and present and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the land and lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today. Today we'll be hearing from a number of stakeholders, including various unions, the New South Wales Division of the Liberal Party of Australia, academics, representatives from the Centre for Public Integrity and the Accountability Roundtable, and the New South Wales Electoral Commission. I thank everyone for making the time to give evidence to this important inquiry. Before we commence, I would like to make some brief comments about the procedures for today's hearing. Today's hearing is being broadcast live via the Parliament's website. A transcript of today's hearing will be placed on the committee's website when it becomes available. In accordance with the broadcasting guidelines, the House has authorised the filming, broadcasting and photography of committee proceedings by representatives of media organisations from any position in the room and by any member of the public from any position in the audience. Any person filming or photographing proceedings must take responsibility for the proper use of that material. This is detailed in the broadcasting resolution, a copy of which is available from the Secretariat. While parliamentary privilege applies to witnesses giving evidence today, it does not apply to what witnesses say outside of their evidence at the hearing. I therefore urge witnesses to be careful about comments you may make to media or others after you complete your evidence. Committee hearings are not intended to provide a forum for people to make adverse reflections about others under the protection of parliamentary privilege. In that regard, it is important that witnesses focus on the issues raised by the inquiry terms of reference and avoid naming individuals unnecessarily. All witnesses have a right to procedural fairness according to the Procedural Fairness Resolution adopted by the House in 2018. Owing to the short time frame for the inquiry, the committee has resolved that witnesses be required to provide answers to questions on notice within 48 hours of receiving the transcript of evidence. If witnesses wish to hand up documents, they should do so through the committee staff. In terms of audibility of the hearing today, I remind both committee members and witnesses to speak into the microphone. As we have a number of witnesses in person, it may be helpful to identify who questions are being directed to and who is speaking. For those with hearing difficulties who are present in the room today, please note that the room is fitted with induction loops compatible with hearing aid systems that have telecoil receivers. Finally, could everyone please turn their mobile phones to silent for the duration of the hearing. So once again, thank you and welcome Mr. Maury and Mr. Yap. Oh, sorry, I've got more to say. I now welcome our first witnesses. Could each witness, starting from my left, please state their name and position title and swear either an oath or affirmation.
Ed Yap, Senior Legal and Industrial Officer at Unions New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you, Mr. Yap. Mr. Maury.
Mark Maury, Secretary Unions New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. Would you like to start by making a short statement?
No, I think we've made our statements to this committee a number of times. I think our position's pretty clear, Chair.
Great. Thank you very much. We'll now proceed to questions. I'll have 10 minutes for the 10 minutes for the equal time opposition.
Great, thank you. Thank you for your attendance today. Mr. Maury, did you see a copy of the bill before it was tabled in Parliament?
I'm just trying to think. I can't recall, no. I don't think I did. I remember talking to people about it. I don't know that I saw one before.
So you were consulted on the bill before it was proposed?
Yeah, I was asked in the context of the High Court case what we believed was legal and what wasn't legal. I mean, we're the only organisation that's run 3 High Court cases, so a bit of an authority on it.
And who asked for your advice at that time?
Point of order, Mr. Chair.
Point of order taken.
Just a bit concerned how this fits within the terms of reference, which invite obviously an inquiry into the policy issue, whereas this seems to be aimed at some sort of suggestion of a process issue in relation to the government processes around the bill. Just don't see how that's relevant to the terms of reference.
To the point of order, I think that
point of order.
it's important to know the consultation that went in behind the bill as well. It's an inquiry into the bill as it's presented before Parliament. I think it's highly relevant.
Yeah, I will rule on that. I won't uphold the point of order. I do think that the consultation process is within the remit of the terms of reference, so I will allow the question.
So you obviously appeared before the Joint Standing Committee on Electoral Matters previously. You've seen a copy of that report. And do you agree with the recommendations in that report?
Look at certainly identifying the appropriate caps. I think that was good. We have a different position on acting in concert. Don't agree with that. I mean, if the Electoral Commission could distribute clear and accessible information, that would be good, but I'm not sure they've done that in relation to this. And the by-election cap to be increased,
So the
we agree
report,
with.
So
because
the report,
for us, that last one is that the previous cap was 20,000. You can't run a campaign on 20,000.
Yeah, so in the past, if you look at some of the previous by-elections where Unions New South Wales were active, so for instance Strathfield, Monero and Bega as recent examples. In Strathfield, Unions New South Wales spent $14,530, $3,844 in Monero and $11,126 in Bega. So that was all well and truly under the $20,000 cap. So what problem are you trying to fix by increasing the cap above the $20,000 limit if in recent examples you have been well and truly under that cap anyway?
Well, we're not trying to fix a problem. The High Court's saying there is a problem. That's
But you
the issue.
support increasing the cap from 20,000 to 220,000.
And that was the, I think I have given evidence that I believe there shouldn't be caps, that cap, there is a cap, it should be much higher. I think in our last submission we put in a budget on how you'd run a campaign. At $20,000, running a campaign in a by-election doesn't give you enough money to mail every person in the seat, let alone do anything else. And for us, the biggest thing that consumes the amount of money that we spend is having to declare the wages of staff working on that. And so you make a judgment call about how much you can and can't do in those areas. And in relation to those ones, we're at a significant disadvantage. And the way that we addressed that was running, I think, mainly social media campaigns in those areas. It's really restrictive.
Mr. Murray, just before we move on, before the point of order was taken, I just want to clear up. One, you confirmed that you were consulted on the bill by government, is that correct?
Yeah.
Yeah, so by which minister or by who in government?
It was funny because they rang, I think it was John Graham's office said there was a bill coming up. They said they'd send me the information. I never got sent the information, but I did get the information once it was into the Parliament.
Right.
Like the bill itself.
So the first question from my colleague, Mr. Rath, was...
if you're asking me, did I collude with the government to introduce a bill?
I'm asking specific questions about how the policy was formed.
That's exactly what you're asking.
I'll
say I didn't.
I'm here to ask the questions, Mr. Murray, not you.
Well, I'm not going to have my integrity.
I'm asking some specific questions,
where you are going,
Mr. Murray.
you are suggesting things in your questions about what happened, that you're suggesting there was some sort of collusion going on, and there was not.
So to the first question, which you were unsure about, and if you need to take it on notice, that's
Yeah,
perfectly
happy to take it on
fine. Around were you provided a copy of the bill before it was introduced?
No,
So
that's my recollection, but I will take it on notice and go back and confirm
Thank you.
for you.
And so I agree that that there's currently no cap. The High Court didn't recommend what the cap should be. Why do you need a $220,000 cap when you're not even spending in the most recent set of by-elections at $20,000?
But you're saying why do we didn't come to the figure?
Well, what do you think
That's
the
the
appropriate
figure.
cap should be?
Well, I know that with the general elections, it's around about 75%, I think, was the recommendation. The High Court points out that no voice should be drowned out in an election, and I think that applies to not only political parties but third parties as well. And when legislators make the legislation, they need to take account of that.
Well, I accept that no voice should be drowned out, but the voice that's being put forward is often highly similar to the same information that's being put out by New South Wales Labor. I mean, a lot of the material cannot be even differentiated. As an example, by the Australian Services Union, don't risk the Liberals from, in their negative campaign material. It seems remarkably similar to that by New South Wales Labor. I mean, isn't it basically identical material that's being put out by unions in New South Wales and your members from that coming out from New South Wales Labor head office?
I don't see what the difference is between that and, say, the former Premier Berejiklian campaigning in a National Party seat in Upper Hunter, where they're two different parties. That's working together. In terms of Sydney Water, I think a range of people agreed it was a pretty stupid idea to try and privatise it, and people said, we're not going to cop it.
So you believe then that in a by-election, for instance, you should be allowed to spend, each union should be allowed to spend up to $220,000 or an unlimited amount of money, to take your earlier point, plus Labor should be able to spend their cap as well. So essentially, the 18 or 19 different unions that are affiliated with the Labor Party all should be able to spend $220,000, and then Labor should be able to spend $220,000 as well. How's that fair?
I don't think I'm saying that. What I'm saying is the High Court said that we have a right and a freedom of political expression in an election, be it a state election or a by-election. Now, I'm not a legislator, I'm a union leader, so I don't legislate the numbers. That's for you people to work out what number is appropriate. And I think there's guidance from the High Court. So to say that I just want that is not necessarily right. I believe that the High Court's position that no voice should be drowned out is something that this committee needs to take on, the legislators need to take on.
Thank you. I'll now turn to the crossbench. Ms. Fairman.
Thank you, Chair. Thanks for appearing today. Just to go back, following on really from the opposition's questions. So you are here today, though, before a committee. Yes, we're determining the amount, but you're a significant stakeholder and would have a fair idea of what that amount should be, and no doubt you're talking to various MPs about that. So if you could give us some kind of guidance, please. Mr. Morris, you said earlier that you don't think that there should be caps. Is that the Union's New South Wales official position, that there shouldn't be caps at all?
Well, that's that's what I think. The organisation has run 3 High Court cases because the caps that have been set do not allow you to actively campaign, for example, in a state election. The cap of 1.3 million doesn't buy you enough to participate in a media market. It is hard to then run a statewide campaign. You have to then be reflective of how you use your cap. We've got to count the hours people work and those sorts of things. So our bang for buck in a state election is greatly reduced, even though the cap's higher. In relation to a by-election, I think there should be, whatever the caps are, they should be appropriate. allow people to participate in the by-election, but not drown out the voices of other parties.
So does appropriate in your case then mean equal to what the cap is for individual candidates and political parties, for example, for every single third-party campaigner that chooses to campaign in that by-election, as was just mentioned, 15 unions or so. Is that your view today, that it should be equal, that it should be higher, that it should be less?
Well, I think the rule of thumb that people have been
Or that there should be no capital?
I think the rule of thumb that people are running by is it's about, I think the third-party count was about 75% of what an individual party could spend. And I think in a by-election, it's usually over a 4-week period, not a 6-month period. So I'm not going to be stupid and say we should be able to have $10 million to spend on a by-election. That's ridiculous. But it comes back to that principle of whatever's set, the figure that's set should allow people to be able to campaign as third-party campaigners, but not drown out the voices of the candidate. So I don't think more than the candidate would be appropriate for an individual organisation. And the rule of thumb at the moment seems to be 75%.
So coming back to the last state election, you were just talking about the caps and how it was quite restrictive.
Mm-hmm.
Explain what you mean by that. Like, what activities of Unions New South Wales did the current cap legislation curtail? What would you have done differently?
Well, for a start, there's no way you can access the media market in Sydney.
In terms of TV?
In TV, the standard sort of media markets, TV, radio, there's a premium on those advertising slots when election is called. They increase the price on those. So there's no way that Unions New South Wales as an organisation could participate in that. The organisations that potentially could would probably be the nurses and the teachers who have the ability to do that. But even for them, that cap makes it very difficult for them. The other part of the cap for us is that we're counting staff hours. And so the way in which we structure a campaign is we don't have people on, for example, the last one we had 5 seat organisers who were working 3 days a week, part-time and on the weekend to ensure that we stayed below the cap. So it does put a burden on what you actually do. And things like research are counted in it. So if you do research, research isn't cheap, and we did a lot of research to get our message right for the last state election. So by the time you've actually got a message, you're then in a situation with not being able to promote it as much as you would simply because of the caps.
Thank you.
Mr. Borzak.
Yeah, thanks, Chair. Mr. Morey, does Unions New South Wales always act in consort with the ALP when it's campaigning?
No, we don't. In fact, I think you've seen over the last couple of weeks where the union movement has a very different position to the ALP government, particularly around teachers.
Around teachers?
Yeah, well, we've been campaigning with the teachers against the government, so no, we aren't hand in hand.
Would you expect that situation to change during an election campaign?
We run our own campaigns because a number of our affiliates, and the two I just mentioned, the nurses and the teachers, our two largest affiliates, neither of them are affiliated to the ALP. In fact, I think it'd be fair to say they have links closer to other parties in the parliament. And so for Unions New South Wales to simply go out and run an ALP campaign, we would have a massive backlash from significant unions who are not affiliated to the party nor wish to be affiliated to the party. So we have to run a campaign that captures the issues for our members, and that's why Essential Workers Deserve Better was our campaign. We also didn't hand out on election day. We didn't go to booths and put material out as Unions New South Wales with a how to vote.
Well, that goes now to my next question, was how closely, if at all, do you coordinate with an ALP campaign?
I think it's fair to say that some of the issues do overlap. I mean, certainly the Sydney Water one was one that overlapped. We're against privatisation. The party was against privatisation, so there was an ability to coordinate that. But then so were the Greens against privatisation, and we would speak to Jenny Leong around that as well. So it's not like we only speak to one party. We speak to all parties, and we speak to all crossbench parties.
Okay, so it is, you would expect your union members and affiliates to separately organise their own campaigns and at times coordinate with yourself and perhaps also coordinate with the ALP, but it's not monolithic.
No, so for our last campaign, we were unable, until the High Court case, or until the Upper House got rid of the legislation around acting in concert, we were unable to talk to our affiliates during that period. So we did what we usually do, try and come up with a message that is an umbrella that we can have out there during an election campaign that allows affiliates to run their own issues. For example, teachers, on number of teachers in schools, nurses, safe staffing ratios, the HSU around paramedics. They all want to run their own specific issues in a campaign. So for us, we have to have something that's overarching that allows them to run their own specific campaign but have an overarching narrative to it.
So you don't have any ability to instruct them,
No.
as the ALP obviously doesn't have either.
No, there are separate organisations. They're affiliated to us, but we have no ability to direct them to do anything that is done through their own democratic processes.
How would you expect the unions or your affiliates to coordinate if they were to coordinate?
Well, the argument that
Through you or?
we're the Peak Council. They're affiliated to us, and our argument has always been we don't have the luxury or the resources that, say, a big bank does or a mining company. We pool our money and resources from our members and use that money in an election campaign. But I think, as you can see from the returns, there's very few unions that ever spend up to the cap, and those that do are large unions who are running their own individual campaigns.
So does Unions New South Wales get contributions separately from its affiliates towards an overall campaign for the union body?
We have a process where we have a commitment that 20% of our revenue goes into a campaigning fund, and that's for any campaign we run in an election cycle or outside an election cycle.
Okay, thank you.
Thank you, Mr. Morrow. I'll now turn to questions from the government.
Thank you, Mr. Morey. Without traversing old ground for too long, with respect to the High Court challenge, am I correct in saying that the conclusion was if the law burdens implied freedom of political communication, it must be justified, and that the court held that a third-party campaigner could not possibly present its case within the expenditure limits as they then stood?
That's correct.
Do you agree with the conclusion of the former chair of the Joint Standing Committee on Electoral Matters in his forward to the last Electoral Matters Committee report that stated that the committee accepted the evidence of various stakeholders that the current cap makes it very difficult for third-party campaigners to participate effectively in campaigning during by-elections?
Yes. I also note they used Business New South Wales as evidence, and they didn't use the Minerals Council, who the last appearance said the first time I've ever agreed with the Minerals Council on the election stuff. The election bill or the legislation is all over the place.
So, noting the general principles that the High Court settled, and the resources required effectively for third parties to be able to campaign,
Yep.
would you anticipate third parties spending roughly the same amount within seats to have their voice heard adequately, whether it's a single by-election, multiple by-elections on one day, or a general state election?
I think it's different. General state election, as I said before, it's difficult because it's over a 6-month period, whereas a by-election is over a 4 or 5 week period. And so the cap that you have in a by-election, if you don't want to drown someone's voice out, you would think it couldn't be more than what the candidates are getting.
You refer to the longer period within which there are expenditure caps for general elections. Would I be correct in assuming then that in those contexts, if there is a 6-month period within which expenditure can be incurred, that it would be justifiable to have a larger cap in a general election context rather than a single by-election?
Yes, because you've got a longer period in which you have to campaign. That's why we campaign against the caps in a general election, because they are so restrictive.
Just with respect to the nature of expenditure that falls within these electoral caps, what I'm interested in is the nature of expenses that might not ordinarily be considered political campaigning by a layperson, and you referred to research as one example.
Yep.
What other types of expenditure would fall within the electoral expenditure definition, as loosely worded as that is, that would fall within a cap over a 6-month period?
So for us, it's about working out what is business as usual versus what then falls under the cap. Arguably, some business as usual stuff could be considered under the cap. Certainly if you're using, say, cars, driving material around, that's under the electoral cap. Say we were campaigning on an industrial issue, at the time I think rail, the last government was in a fight towards the end of the year with the rail union. Us supporting them, you have to be careful in the expenditure period. Are your actions that you're actually doing asking people to think about how they vote or suggesting how people should vote, which is the test in the legislation. So we have to be really careful about how we frame our campaigns and what we actually do. We are on the side of caution, which means we probably declare more than arguably you could, but that's just to make sure that we abide by the Electoral Act. But things like research, doing a phone bank, for example, to raise awarenesses of an issue, that could arguably be considered as electoral expenditure during that period, depending on what your script is and what you say. So there's all those sorts of things that we do. You have to make a judgment on whether it's business as usual or as electoral expenditure, and whether you can defend it as business as usual. But that makes it difficult. That's one of the problems of the current electoral laws, is our business as usual stuff generally gets caught up in the electoral expenditure because we're advocating against the government.
Is it a fair characterisation to say what you or your affiliates might class as an industrial campaign would get caught within the electoral expenditure caps out of an abundance of caution?
I mean, I think if we're past the 1st of October, when the when the cap period starts, you couldn't go out and say you could run a campaign. This government is attacking rail workers. They should get a pay rise, right? You can say that. I think that's business as usual. If you say this government is attacking rail workers, they should get a pay rise, and you need to vote the government out, that's arguably electoral expenditure. So there is a cooling effect on the way in which you advocate for the issues you have in the movement during an electoral period.
Thank you. Any further questions from the government?
Yeah, just to...
Oh, you first.
Yep, okay.
I just note we've only got about a minute and a half
okay.
left to go, so you might want to
Mr.
make it quick.
Morey, there's been a suggestion made in the Liberal Party submission that there should be a prohibition on registering as a third-party campaigner if an organisation is affiliated to a political party. Just wanted to get your view on that.
Well, I think that was in the first High Court case where they tried to aggregate the fees of affiliates, affiliation fees to the ALP as part of the electoral cap spending, and the High Court threw that out.
Yeah.
I don't think that's appropriate.
So in your experience in the Labor movement, does affiliation with the Labor Party by a trade union mean that that trade union supports all the policy positions of the Labor Party?
I don't think so, and I think the most recent example would be the HSU and their very active and very public campaign against the government around salary sacrifice. Yeah. They are affiliated to the party, but you could say they went to war with the party they're affiliated to over an issue that was so important to their members who directed that organisation through the democratic process to campaign on it, that their affiliation to the party was secondary to the primary role as a union to campaign for their members.
So if such a proposal passed into law, do you think that your organisation might take another trip to Canberra and challenge that law in the High Court?
We would,
Yep.
yes. And I think from the first case, there's enough from that decision to say that it would be unconstitutional.
Yep. A similar proposal is put forward by the Liberal Party in relation to donations. Have you got any views on that? And that is that if you donate, you shouldn't be allowed to register as a third-party campaigner. What's your view on that?
Well, if you can stop the mining companies, the banks, campaigning as well when they give their donations, we'll have a look at it.
Yes, please.
Thanks. The time for questions has concluded. Thank you very much for your evidence today. We very much appreciate you appearing at short notice. And to let you know, we have extended to unions, New South Wales, an extension on your submission period to allow you to make a
Great.
written submission. So
Thank you very
we'll
much,
welcome
Chair.
that and report in due course.
And I think there's one thing on notice to come back to you on as well.
Yeah, thank you very much.
Thank you very much.
Mr Stone, thank you very much for appearing at this inquiry into the Electoral Funding Amendment Bill. Could I ask you state your name and title and then swear an oath or affirmation?
Sure. Thank you, Chair. Christopher Stone. I'm the State Director of the Liberal Party of Australia, New South Wales Division. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you, Mr Stone. Would you like to make an introductory statement or submission? And
I would if the committee is happy for me to do so.
yes, as long as it doesn't run for more than, just a couple of minutes, that would be appreciated because we'd like to ask some questions.
I'll try and race through it, but just stop me when you'd like me to.
Okay, thank you.
Thank you for the opportunity to make the submission to this inquiry. The last time the applicable caps on the expenditure of third-party campaigners was explored by the Joint Standing Committee on Electoral Matters, or JSCEM, in 2022, relevant stakeholders, including the New South Wales Liberal Party, were focused on campaigning ahead of the federal election that was called during the inquiry submission period. I was unable to provide oral evidence to the JSCEM in July 2022 as I was recovering after hospitalisation for a cardiac procedure. The proposal contained in this bill to increase tenfold the applicable cap for third-party campaigners at by-elections is a selective adoption and expansion of the recommendations made by the JSCEM inquiry, which heard no evidence from either the Liberal Party or the National Party. Further, the JSCEM has not inquired into any proposed amendment of Section 2912B to amend the additional cap applicable to third-party campaigners in individual Legislative Assembly seats at general elections. We would argue that is an unreliable basis for making amendments to the existing law and ultimately undemocratic in the manner that it operates to unreasonably and disproportionately restrict the freedom of political expression guaranteed by the Australian Constitution. Fundamentally, the bill disturbs the balance that already exists between the caps for third-party campaigners and candidates in the Electoral Funding Act. It benefits trade unions and their political wing, the Labor Party, by allowing an excessive uplift in the cap for third-party campaigners, an almost tenfold increase. It destroys the relativity between candidates and non-candidates and is particularly harmful to minor parties and independents. Put simply, these amendments will distort the democratic process and have a direct impact on the electoral outcomes in New South Wales. We argue that the proposed amendments to sections 2911 and 12B in this bill cannot be viewed in isolation. Rather, they are part of a complex regulatory framework which includes caps on both political donations and electoral expenditure. It is already an uneven playing field, one that significantly advantages the Labor Party over every other political party or independent candidate that participates in New South Wales elections. Through its interdependent relationship with the trade union movement, the Labor Party receives significant financial and electoral benefits through several means. One, affiliation fees paid by 19 trade unions totalling approximately $1.8 million each year. Two, political donations, which in 21-22, the last full financial year of disclosures currently available, came from 9 trade unions and totalled $48,680. And 3, third-party campaigns where trade unions vastly outnumber all other interest groups that register and can spend millions of dollars backing in the Labor Party's campaign messages. We do not deny a trade union's right to choose to affiliate, to donate or to campaign as a third party, but we argue that trade unions should be able to affiliate or donate to the Labor Party or campaign as a third party, but not both. We acknowledge that a third-party campaigner's implied right of political communication, which has been upheld by the High Court, but they are not running for public office. This distinction is important when considering the relativity of the caps that are set. At a general election, the cap, as part of the overall cap of a third-party campaigner, can be directed at electorate-specific expenditure under Section 2912B. This increase in the amount under Section 2912B, exacerbated by the absence of any accompanying acting in concert provisions, will mean that affiliated trade unions can coordinate their efforts and direct their additional caps in a targeted manner to those marginal seats where the Liberal or National parties, minor parties or independents may hold seats, or where there are tight contests. This point was acknowledged in submissions by trade unions, including the New South Wales Nurses and Midwives Association, to the JSCEM inquiry last year. If this amendment were to be adopted, you would see a greater impact by third-party campaigners concentrated in fewer seats. The Electoral Funding Act requires a significant overhaul to address these inbuilt inequities. Currently, the Act allows the Labor Party to have its cake and eat it too. Trade unions that choose to affiliate with the Labor Party, paying its significant fees each year for the privilege of attaining rights to vote at its annual conference, to be represented on its administrative committee and to influence its policy direction, are arguably not third parties at all. That is their right and that is their choice. However, in making that choice, they should not be then permitted to also register as third-party campaigners, nor should they be able to make political donations. We submit that the applicable cap for third-party campaigners should be limited to no more than 15% of a cap applicable to a candidate, consistent with the relativities in the Electoral Funding, Expenditure and Disclosures Act, which previously enjoyed bipartisan support. However, the JSCEM should be asked to look at the current Act holistically, and we make further suggestions on that in our submission. And again, I thank you for the opportunity to appear today.
Thank you, Mr Stone. I'll now turn to questions from the opposition.
Thank you. Thanks, Mr Stone, for appearing today. Could you, for the benefit of the committee, please provide what your experience is when it comes to campaign and electoral funding matters?
Sure. Look, I've worked in and around New South Wales and Australian politics for nearly 25 years. I was a senior advisor to the former Prime Minister John Howard. I worked as both a consultant and campaign manager for the New South Wales division between 2008 and 2011, and then as State Director since 2016, working on multiple by-elections and general elections through that period.
And has the Liberal Party or the National Party ever received any donations from the trade union movement?
I don't recall we ever have.
Do you think that third parties should be entitled to an equal or greater ability to persuade voters than a candidate or a party?
No. I mean, they have a role to play in the electoral process. There is no denying that. But this is about proportionality. Ultimately, a candidate is on the ballot paper. They are the ones who should have the greater voice in talking to voters about the issues that concern them, because ultimately they're seeking election to represent them. Third-party campaigners have a role to play, and as the guidance on the Electoral Commission website points out, they generally are trying to bring attention to particular issues or the like, and that is certainly their role. But you know, should that voice be equal to that of a candidate that is seeking election to public office? I think this issue of proportionality is key to consideration of this bill.
In terms of proportionality, obviously if you're going from about a $20,000 cap to a $220,000 cap for third parties, it's not just the Liberal Party or the National Party that will be impacted. How do you think it will impact independents and minor parties if that was to be legislated?
Well, I mean, ultimately, this could happen in any seat. And at the last election, there were, certainly in the seats that the Liberal Party contested, there were probably about 8 contests that came down to a 2-candidate preferred vote between the Labor Party and either the Greens, Independents or One Nation. And in a situation where third-party campaigners had a cap of $225,000, where they could concentrate their efforts into those individual seats, you could end up seeing electoral outcomes that are quite different as a result.
And I was just wondering if you could run through with us, in your submission, you went to great lengths to explain some of the history here with the expert panel as well as the JSCEM recommendations, both of which recommended in-concert provisions. Could you talk more to the in-concert provisions and why they're important?
Well, I think from my submission, you would have seen a number of case studies that looked at some of the recent by-elections over the past few years, where multiple unions registered as third-party campaigners, campaigning on issues as they are legitimately able to do, or with a consistency of message and generally a message that is against the coalition side of politics. Really that question around, should they be able to aggregate their collective caps for the purposes of campaigning against candidates or against political parties is fundamentally the question here. They all have a legitimate role to play, but if they're all working in a coordinated way to aggregate their caps, arguably the result is disproportionate and will have a direct impact on electoral outcomes.
Thank you, Mr. Stone. Can you provide, or I suppose in your 20 plus years experience, do you have any sort of real examples from probably more recent election campaigns of third parties attempting to influence an election outcome in favour of a particular party?
Well, I mean, we saw it at the recent state election. The privatisation of Sydney Water. This was a message that was being communicated by the Labor Party and by various unions. There were annexures in my submission where there were examples of collateral of campaigning that was happening on the ground, where there was essentially a consistency of message and with a tagline to essentially vote the government out or to vote Dom out. So, I mean, there is an example 6 months ago, and at by-elections in the past, as I've set out in my case studies, similarly, we've seen a broad consistency of message.
Have you ever seen in your experience, and I think my colleague sort of asked this, but I'll ask it in the context as a National Party MP, have you ever seen a trade union ever promote or ever put out there to put Labor last in a three sort of party contest in your history in 20 odd years?
I don't recall seeing that.
So it's clearly, would you say that it's never been just the Liberal Party or National Party? You've never actually, in your experience, seen where they've instructed voters or promoted to voters to put Labor last?
I don't recall it. I can't, in absolute terms, say that it hasn't happened, but I don't recall it.
Mr. Stone, I refer back to, if we go back in time with your experience, 20 plus years experience, back to former Labor Premier Christina Keneally back in 2010 when she introduced, or the then government introduced, the Election Funding and Disclosures Amendment Bill 2010, and obviously the precursor to today's Electoral Funding Act 2018. Now, the then Labor Premier said, and I quote, "These reforms are about putting in a limit on the political arms race under which those with the most money have the loudest voice and can simply drown out the voices of all the others." Would you say that what the now New South Wales government is proposing in the Electoral Amendment Act is doing exactly what the then Labor Premier was trying to stamp out?
Well, I'd probably make a couple of points. Firstly, there's been no evidentiary basis for putting forward these proposals, and particularly 2912B has not been explored by the JSCEM at all. I make the observation that that bill, having been introduced in 2010, enjoyed bipartisan support, and those provisions were in place for quite a number of years before ultimately the Electoral Funding Act was introduced, and we saw a couple of challenges in the High Court of Australia. So this is a departure from what was a bipartisan position over quite a number of years.
Thank you. I'll now turn to the crossbench. Ms Fairman.
Thank you, Chair. Mr Stone, in your submission, you mention the Section 2912B and the fact that that wasn't considered or recommended by in the last Parliament JSCEM inquiry. What are your thoughts as to why that is being brought up? Why is it being put forward in this bill? Do you have views on that?
It's hard to know. Obviously, the government needs to deal with the absence of a cap on by-elections because of the finding of the High Court. But one has to question why they are making changes to a different section relating to general elections when, as far as I can see, there's been no call for it, and there's been no, inquiry into it by the JSCM, which has been the body over many, many years that has looked carefully at electoral laws in New South Wales. So it's hard to know what the motivation is, whether they are simply trying to align the caps at a by-election with a general election. It might be as simple as that, but without the JSCM having looked at this issue in the past, it's hard to know why that's being done now.
And could you outline your concerns for the committee again in terms of section 2912B?
Sure. Well, I mean, in a general election context, third-party campaigners can register and get an overall cap, and then within that they have this additional cap that they can spend in particular electoral districts. So what this means is a tenfold increase in the amount of money that they could spend in a single electoral district. And as I mentioned in the submission, there were something like 11 seats where there were 4 candidates that nominated in an electoral district, and there were about 24 seats where there were 5 candidates that nominated in an electoral district. Now, in those circumstances where there's a small number of candidates in the field, and then you have the ability of third-party campaigners to then register and spend up to the same amount as a candidate, you can expect that that's going to have a significant impact on the electoral outcomes in the seat. And within those 2 groups of seats where there were either 4 or 5 candidates, there were quite a number of marginal seats that changed hands during the course of the last state election. So it's a material impact that would occur, and it's not just Labor-Liberal contests. It could be Labor-Green contests, it could be Labor-Independent contests where third-party campaigners line up and spend the same amount of money as a candidate.
Thank you. In your evidence, you do talk about the fact that the Labor Party receives donations and various other donations, obviously being affiliated in terms of third-party campaigning as well, that kind of assistance, if you like, during campaigns. What does the Liberal Party receive? Where does the majority of your funding come from?
We receive money from donations and from membership by our members, apart from the administrative
Yes, I'm
funding
aware of the donations. So the majority of those donations, though, where are they from? The business sector?
Individuals, small businesses, yes.
Do you know the rough percentage of what you receive from the business sector, for example, compared to individuals?
Off the top of my head, I don't, but I can take it on notice.
Thank you.
Thank you. Mr. Borzak.
Thank you, Chair. Mr. Stone, does the Liberal Party of Australia New South Wales Division have any third-party campaigners that it talks to and acts in consort with?
No.
You don't have any at all? Nothing?
We don't. I mean, we don't have any organisations that affiliate with us. No.
So you don't coordinate with anyone when it comes to a campaign or anything like that? You don't discuss anything in terms of developing campaign strategies?
Well, I mean,
as was
we're
suggested, for example, by the Union New South Wales do with the ALP?
We're in coalition with the New South Wales National Party, and obviously they contest in their seats, we contest in our seats, and we had a couple of high-profile three-cornered contests at the last state election.
They're a political party, so...
Yeah. But I mean, look, we talk to other organisations, sure, but not in the context of third-party campaigns, no.
Okay. Do you believe that third-party campaigners always and only ever campaign against the government of the day?
If the government of the day is the Liberal and National parties.
So
in the sense that? I mean, ultimately it remains to be seen, at the next state election as to whether trade unions will campaign against the Labor Party. They haven't been in office for very long. But certainly since this Act has been in place, since the Electoral Funding Act has been in place and then its predecessor that was introduced by the Keneally government, during the vast majority of that period, the coalition was in government. as I said, it remains to be seen as to whether trade unions will campaign against the government. But it's very rare, in my experience. I can't think of many, if any, examples of third-party campaigners campaigning on behalf of the government.
No, I'm not, and I'm not saying that should be done. But in your answer, it sounds like you're saying that the only third-party campaigners worth worrying about are the ones that campaigned against the coalition while they were in power, and that happened to be the union movement. Surely that's not your answer.
No, I'm not suggesting that, but trade unions are the vast majority of third-party campaigners that participate in elections.
So the Australian Conservation Foundation and
Sorry?
the Australian Conservation Foundation, for example, and people on the left and the Greens
Oh, God, I wish,
don't do much.
I wish they did.
Well, I just referred back to my submission and case study number 3, which listed the third-party campaigners, or the trade unions that registered as third-party campaigners at the elections. And then I mentioned that in addition to those 26 unions, 7 third-party campaigners were registered by 30 September 22. So there's 7 other organisations. So the vast majority of the third-party campaigners at the last state election, and generally speaking at previous elections, have been trade unions.
Okay, all right, thank you.
Thank you, Mr. Borzak. Questions from the government?
Thank you, Mr. Stone. I note your 20 years plus experience in the campaign space and a very worthy electoral opponent. Just wondering what experience you bring and first-hand knowledge you bring to the decision-making processes and structures of the trade union movement with respect to donations that they make or campaigns they may participate in.
Only to the extent that on the other side of politics, I'm an observer of these things. I don't claim to have any particular qualification, but like anyone else in the political process, I'm a keen observer.
Do you bring any first-hand experience to the strategic and tactical considerations and structures of New South Wales Labor with respect to campaigns?
As I said, I'm a keen observer.
There are a range of competing policy and legal priorities that have to be balanced in consideration of electoral reform. I note that in the most recent High Court judgment, the justices accepted that there was certainly a legitimate need to level the playing field and avoid voices being drowned out during the electoral process, but they also found that there was insufficient evidence to suggest that this was actually occurring or that it was a risk. Do you disagree with the High Court?
It's not about disagreeing with the High Court, but it goes to this issue of proportionality that I referred to before. There are many voices in the community, and there are many voices that are used during an election campaign. But ultimately, it's a candidate that nominates and is on the ballot paper to run for public office. And yes, third-party campaigners have a legitimate role to play in raising attention or concerns about particular issues that are important to those organisations, but there's proportionality here. And I just refer back to the bipartisan approach under the previous iteration of the Electoral Funding Act, the Electoral Funding and Expenditure and Disclosures Act that was introduced by the Keneally government, that was in place for quite a number of years. It enjoyed bipartisan support, and in that act, the relativity was about 10% of a candidate cap. Obviously, there were reforms that were introduced by the previous government to third-party campaigner caps, and Unions New South Wales went to the High Court when that occurred. And obviously, the cases that have occurred since have looked at specific elements of the Act. But again, this just comes down to proportionality. It's not trying to diminish in any way anyone's voice, but there are more important voices than others in an electoral context when you've got people who are running for public office, as opposed to others that are just simply raising attention or concerns on issues, in my view.
Is it your considered view that the propositions that you have in your submission would withstand scrutiny of the High Court, particularly with respect to placing unnecessary constraints on the implied freedom of political communication?
Well, given previous judgments of the High Court where they've referred to a lack of evidentiary analysis or basis for particular amendments, as I referred to earlier, Section 2912B has, and the introduction of changes to that in this bill is supported by no evidentiary analysis or basis. So one has to question, well, on, taking into account all of the other elements of quite a complex regulatory arrangement under the Act, on what basis do you justify increasing a cap for a third-party campaigner tenfold? And so I guess, my point is that, the implied right of political communication is important to everyone who participates in the electoral process. And I would be concerned that with this bill, there has been no basis for justifying what is proposed.
Are you aware of the JSCEM's analysis of the submissions from the Nurses Association and Unions New South Wales with respect to the cost of running campaigns?
Yes.
Within by-elections? Do you disagree with that factual analysis?
I do, and I referred back to my submission. In their submission to the JSCEM, they included some draft budgets which justified their proposition that the caps ought to be set at $198,000. And the assumptions built into that campaign budget were on the basis that in 3 metropolitan by-elections that you would run $100,000 worth of TV advertising and $35,000 worth of radio advertising. Now, as someone who has also run a political party and run by-elections in the past, I suspect that you would not have chosen to run TV or radio advertising if there were 3 seats in a metropolitan area at by-elections. I certainly wouldn't. And so, some of the assumptions that are built into a budget that they have used to justify the number that they have picked, I think are flawed. And the JSCEM has looked at a couple of submissions from different trade unions and picked out one that seemed the most reasonable. As I mentioned before, the committee did not hear from the Liberal Party, it did not hear from the National Party, it didn't hear from other political parties as well. And as I said earlier, these things need to be looked at holistically within the complex regulatory arrangement under the Electoral Funding Act.
Would you, as campaign director, run a sufficient campaign on the basis of proportionality that you put into the committee?
As a third-party campaigner, or
as a campaign director of the Liberal Party, could you run a sufficient campaign in a manner that your share of voice could be adequately heard on the basis of the figures that you're proposing to the committee?
Certainly. I mean, if you're running a single issue campaign, trying to bring attention or raising concerns in the community about a single issue, you can run a perfectly sufficient campaign with some flyers, with some digital advertising and the like, and have a targeted result in 3 metropolitan seats. You don't need to run TV ads. You don't need to run radio ads.
Do you accept third-party campaigners don't just run on single issues?
Sorry?
Do you accept that third-party campaigners don't just run on single issues?
Oh, some of them may run on multiple issues, sure.
Thank you. The time for questions has concluded. Thank you for your evidence, Mr. Stone. I think you had one question on notice from Ms. Fairman. And was there...
No, there was just a...
I was going to just raise something in relation to my submission. After I sent the submission in, I noticed one typographical error on page 10 of the submission, where in the first sentence after the heading, it should read, "The Liberal Party is a political party registered under Part 6 of the Electoral Act 2017.
Okay.
So it's just a minor error that I'll just ask.
That will be amended. Thank you, Mr. Stone, for your evidence today.
Thank you.
Thank you.
To the Portfolio Committee number 1, inquiry into the Electoral Funding Amendment Bill 2023. Could I ask, starting on my left, if each of you could state your name, title, and then swear the oath or affirmation.
We need to turn? No? I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Could you also state your name and title?
Lucy Walker, New South Wales Nurses and Midwives Association.
Thank you.
Michael Waits, Assistant General Secretary of the New South Wales Nurses and Midwives Association, AMF New South Wales branch. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
Nathan Bradshaw, Acting Assistant General Secretary of the Public Service Association of New South Wales, and I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you, Mr. Bradshaw.
Good afternoon. My name's Marianne Ledich. I'm the Campaigns and Communication Managers at the Public Service Association. I swear to the evidence now about to be given to me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you. Would you like to make a short preliminary statement to the committee? You would? Okay, well, who will kick off with Mr. Bradshaw?
Thank you. Thank you for the opportunity to address the committee. The Public Service Association, just for some background, of New South Wales is the primary union within the New South Wales public sector with coverage of almost 40,000 members. We have a significant interest in the matters before this inquiry. I think it's key to note that we represent our members' interests, but also the interests of all public servants in New South Wales. But we do this 365 days per year, regardless of the political cycle. We're not affiliated to any political party, but we do engage with all members of all political parties, independent candidates and members of Parliament and other unions with members in the public sector who we share coverage with. We note the changes contained in the bill are increases to limits on the ability of the PSA to represent our members. And I'd like to note that any attempt to control or limit our expenditure around elections can seriously inhibit our ability to function effectively because of that interest that we do 365 days a year. Our long-running campaign, such as the public sector, deserves a pay rise cut across the traditional electoral cycle. Therefore, to impose limits on specific election expenditure can impact upon our core functions and impose severe restrictions on our operational effectiveness. And in our view, registered state-based unions should be exempt from the third-party provisions of this Act entirely. However, given that this bill does represent a significant increase to some of those very strict restrictions on our ability to represent our members, we do support the acceptance of the bill. And briefly, we note that the related issue of acting in concert has been raised as part of the debate on this bill. Previously, acting in concert provisions have been used to neuter the activities of trade unions through an ambiguous and broad usage of the acting in concert. And we further note that the legal standing of such provisions remains contentious, and so we do, along with the rest of the union movement, support the removal of Section 35 from the legislation. Thank you.
Thank you, Mr. Bradshaw. Mr. Waits, you would like to make a brief submission?
Yeah, thank you, Chair. So the New South Wales Nurses and Midwives Association welcomes the Electoral Funding Amendment Bill 2023 to increase the by-election cap on electoral expenditure by third-party campaigners from $20,000 to $225,900, indexed for inflation. The New South Wales Nurses and Midwives Association represents over 76,000 members across New South Wales, over 50,000 of those within the public sector. This amendment acknowledges that the previous $20,000 cap was manifestly inadequate to run any kind of meaningful campaign, certainly not in a small electorate and even less so in metropolitan areas. The New South Wales Government is the employer of the majority of our members. Obviously, as a union, we advocate our members' ambitions to their employer. We need to be able to influence decisions on wages, staffing levels and working conditions. A government's policy approach to these matters has huge impact on our members, and therefore we have a right and obligation to influence those policies. Given our democracy, we have a right to inform the community of the impact of those policies on the services that our members provide. Put simply, we need to be able to campaign in order to be able to gain better lives and working experiences for our members and to achieve a better healthcare system for our community. In 2011, the New South Wales Government chose to remove the powers of the New South Wales Industrial Relations Commission to determine the outcome of wages and conditions for our members. If we cannot argue our case in an industrial court, we have no other option than to argue our case in the court of public opinion. When your employer is the government, that means elections are an important moment. The cap increase to $225,900 allows third-party campaigners to execute a worthwhile campaign that allows our voice to be heard, and for the voters to hear and understand the arguments presented by all political participants. Thank you.
Thank you, Mr. Waits. Questions now from the opposition. Mr. Rath.
Thank you for coming in today. To both unions, are you affiliated with Unions New South Wales?
Yes.
Yes.
And Unions New South Wales is affiliated with the New South Wales Labor Party?
No, it's not.
No.
Affiliates of Union New South Wales are affiliated to the Labor Party. We are not.
Yes, you're not. I know that. But what sort of membership fees or affiliation fees do you pay to Unions New South Wales?
We can take that question on notice. Happy to
for
provide
both,
it.
both unions. In 2018-19, so the state election before last, for the Nurses and Midwives Association, you spent $1,012,214.26 on third-party campaigning for the Legislative Council. I know we're still waiting on the figures for 2022-23, which will be provided shortly, I assume, through the Electoral Commission. Do you agree that that's an incredibly large amount of campaign expenditure, over $1 million for the Legislative Council?
No.
Do you think that's a fair amount?
When you look at the costs of running a campaign, a meaningful campaign in this state, when you are competing for media space, it is an expensive process. So it is in line with the expenditure of other organisations.
And of that, and for 2022-23, it would probably be a similar amount to the $1 million spent in the 2018-19 election.
It's under the cap, and as you say, we are preparing for those final figures being provided.
And of that $1 million in 2018-19, would you say that campaign expenditure disproportionately favoured New South Wales Labor in their campaign efforts?
What that campaign did was backed in the political party that was delivering on the key ask of our members, which was safe workloads in our public hospitals.
Which Labor's since disbanded their approach.
That is incorrect.
On nurse-patient ratios.
The current Labor policy, which I am part of the task force
Point of order.
to...
Point of order, Mr. Chair. I don't know how this is relevant to the terms of reference.
Yeah, I will uphold the point of order. We've got a very narrow remit to interrogate the electoral funding amendment bill. So I appreciate the political discourse, but if we could keep the questions and the answers to the subject of the inquiry, that would be appreciated.
And has any of your campaign expenditure over the last 4 or 5 years helped the Liberal Party in any way, or the National Party?
Has the Liberal National Party helped us in any way?
That's not the question. But
I kind of had it coming though.
So, in terms of,
I'm happy to answer the question
okay,
if that's required. We provided support to the political parties that were supporting our campaign. So that was a broad spectrum of both independents and political parties. Were the Liberals and Nationals a part of that? Unfortunately, no, because they weren't backing our campaign.
So when you say in your Facebook post, for instance, Perrottet says ratios don't work, who do you trust when it comes to safe staffing? That's a deliberate attack on the Liberal Party in the last government. But you don't think that that's benefiting the Labor Party in any way?
It's an open-ended question, and it was a statement of fact connected to that open-ended question. There were lots of political parties and independents who were supporting our campaign.
So a question for both the New South Wales Nurse and Midwives Association and the PSA. In the history of both organisations, have you ever supported a major political party other than the Labor Party?
Well, I'll just answer. I mean, we provide a lot of our activities when it comes to elections will be holding forums that invites members from any political party to attend and to answer questions from our members. So I think you can't sort of look at it in one angle like that, and I think that we provide the opportunity for all members, whatever political party, to be involved and to answer questions and to take action on the interests of our members.
So for the PSA, and as following on from my colleague, so in 2018-19, $441,970.44 was spent on third-party campaigning for the Upper House, the Legislative Council. So again, I would ask, do you agree that it is, one, an incredibly large amount of money, and two, that it disproportionately favoured the New South Wales Labor Party?
Well, I don't agree with respect that it's a huge amount of money when it comes to the cost of advertising and running a campaign. And if it benefits a political party that is standing up for our members, well, I invite the other political parties to also take the same interest.
Just going back to my original question, are you happy for both organisations to take it on notice to check your archives to see if you've ever supported any major political party as a third-party campaigner other than the New South Wales Labor Party? Mr. Waits?
We can check it, and I'm happy to answer. Well, sorry, I'll rephrase that. It is my understanding that we have not campaigned for the Liberal Party or the National Party in an election on the balance of what either party has been offering our members with regard to their working conditions, with regard to the industrial relations system that controls what those members can and can't win within their awards, and within the aspirations of our members, particularly the Ratios campaign. Again, I'll provide the answer that my colleague here did, that in the last election, had the government come out and said, the Perrottet government come out and said, we support the introduction of Ratios, then we would not have campaigned against them on that front. If we were clear with them that it would have negated our campaign for the Labor Party if there was no difference between the two parties. We campaign in the interests of our members, not a political party.
It's just that that's always the Labor Party, but that's fine. A further follow-up question. Do you think that third-party campaigners should be able to outspend collectively, when you've got more than one third-party campaigner, than an actual organisation, which would be a political party, that is actually putting forward the candidate for the people of that electoral district or state to vote upon on the ballot paper? So my question is, why? Why should a third-party campaigner be entitled to such a significant amount of money to spend in campaigning when they don't actually put forward a candidate to the people in that electoral
Point of
district?
order, Mr. Chair. I don't actually know that is what the bill proposes, so I'd suggest it falls out of the terms of reference.
Order, Chair. I mean, that's a legitimate question, though, with respect in relation to this bill. It was a perfectly legitimate question to a stakeholder regarding electoral expenditure.
Yeah, I'll allow the question. I think it is a legitimate question.
Sure, I'm happy to answer, but could you just repeat the final bit of your question? So repeat the question for me.
Why should any third-party campaigner,
Sure.
Whether it's a PSA, the nurses, midwives, unions, whoever,
Sure.
Why should any third-party campaigner be able to have such a significant cap proposed when they don't actually put forward a candidate as a political party on the ballot paper for the people to vote on in an electoral district?
Sure. Well, we're a voluntary, to be a member of our organisation, it's voluntary. We have over 40,000 members. They pay membership fees. We have an elected central council and executive that approves that expenditure. We're representing over 40,000 members. I don't know how many members are in a political party, but I'd say we have as much right to represent those members who pay their membership fees on the issues that they care about. That's why they join us.
But to the point, I don't actually on principle disagree with what you just said. It is the amount of resources they can use to put forward as a campaigner when they don't actually put forward a candidate.
Just to supplement my answer, I mean, we're open for, we don't put forward a candidate because we're not affiliated to any political party, like as my colleague has said. We represent issues, and in order to speak to the people of New South Wales, the wider public, about the issues for our members, we're required to be able to campaign.
Yeah. So the say that with $1 million you spend in one election. In your submission for the PSA, for instance, you said that there shouldn't be any cap so it should be basically an unlimited amount of money spent, not just statewide, but in each individual electorate. So not only do you think that $1 million statewide is fair, you would contest that, you would contend that over $1 million of expenditure by a third party in a single electorate in a by-election is fair. Is that basically your evidence today?
My evidence? Yeah, the PSA's evidence is that our position is that shouldn't be. Okay.
So over $1 million, so an unlimited amount of money. And this isn't just about unions. It could also be about the Minerals Council or Business New South Wales. You think that it's fair for millions of dollars to be spent in a single electorate in a by-election or in a general election? Is that really your evidence?
As per my submission, it really is my evidence that a cap does limit the ability for us to represent our members. Now, I note that the bill does have the cap. I think it was a recommendation of this inquiry, correct me if I'm wrong. So, I don't think that's necessarily up for debate. That isn't my submission, yes.
How's that a level playing field?
How is it a level playing field for
political parties, the main participants in an election that field candidates to come up against millions of dollars of campaign expenditure, whether it be trade unions or whether it be big businesses or industry groups, to come up against millions of dollars of campaign expenditure, like we're seeing in the United States with their super PACs? How do you think that that is a level playing field for political candidates in New South Wales?
So if I may, the association has a varied view to that of our colleagues, which I think is an indication of how independent we are. Our argument in the previous inquiry was that the cap should be set at 75% of that of the candidate, because we don't see the need to drown out in that example that you're giving. I think when we look at a cap that's in place, it needs to be a cap that allows you to reasonably run a campaign. And as I said before, when you look at the cost of advertising or advertising material, or even putting staff on the ground in an electorate, the previous cap was manifestly too low and actually had a chilling effect on our capacity to campaign. So again, we welcome the current amendment to the bill and the cap that it provides.
Thank you. Now questions from Ms Verma.
Thank you, Chair. Just going on from that line of questioning, if I may. So you said that you presented to the previous inquiry, and that was in relation to the change to Section 2911 that's contained within the bill before this inquiry now. Do you support also, does the association also support changes to Section 2912 of the bill? So there's two sections. I understand that JSCM didn't look at the Section 2912. Do you?
Can you explain to me what the
Have you seen that one? That's changing from 24,700 indexed to I understand 225,000 $900 for third-party campaigners in relation to state general elections. So that's slightly different, I think, to... Have you looked at the bill that is before us now? It's slightly different, I think, to what you presented.
No, I'm specifically prepared for the conversion of the 20 to the 225, so I'm happy to take a question on notice.
Okay, so in relation to your the last state election, how was the association's political communication? Was it curtailed by the laws as they stood for the state election?
Absolutely. There was, given the uncertainty of what the High Court would do with the case and the caps, it had a chilling effect on what we anticipated we would be able to do. As simple as making sure that an individual staff member is not using the wrong language at the wrong time for fear of their time being caught up in such a low cap as was proposed at that time. Once we were clearer about the proceedings within the courts, there was we then had a clearer path for how we could run our campaign and maintain a cap that we felt was appropriate.
Yeah.
So yeah, it had a chilling effect because just the cost of putting staff on the ground and having them educated as to what they can and can't say and what will and won't be captured by a cap when it's so low means that you have to think about where it is you are spending your campaign time and money.
I just wanted to, just to the PSA to Mr. Bradshaw, you mentioned before that you don't agree with caps. You wish the union wishes ideally that there weren't caps in place because of the way in which you campaign, I think, on a day-to-day basis for your members. But I did just want to ask you to clarify in some ways the difference between suggesting or campaigning for the government to scrap the public sector wages cap, that compared to advocating for them to scrap the public sector wages cap and vote a particular party out. There's a difference there, isn't it? One is actually captured under the cap, the other one isn't, which unions can... Mr. Waits, please also jump in because, you know, we grapple with that as a political party as well, but technically you are able to campaign for however many years of a political cycle, say 3 years and however many months, with saying all of that without suggesting voting out a particular government. Isn't that correct?
Well, I think you highlight some difficulties with, when a campaign, changes just because an election has been called. Again, I think that our campaigns, that one in particular, the around the wages, has always been about scrapping the regulation and asking our members to consider that when they're voting. So again, even in the election campaign, there is not a overt vote for any particular political party, but providing, through use of scorecards, etc., on which parties have made promises that align with the values of our members.
But that kind of is the difference, isn't it? As soon as you get into the recommendations around particular parties, even if you're not suggesting a vote, that is the difference in terms of you are able to, I assume, and witness for the 3 months and 3 years and 6 months or 8 months, whatever it is, 6 months, you are able to campaign on the issues pretty effectively, both of your organisations, without stepping into we're now doing activity that we have to, make sure is within the cap because we're campaigning on the issue without suggesting kick out this government. That's correct, isn't it?
Yeah, well, I'm sorry, I don't quite don't
get the question.
Follow the question, but I'm happy to take it on notice if you you want to provide it on notice.
I'm just asking, you were talking about the cap, how you wanted no cap at all, which I'm also challenged because obviously the Greens want, reduced caps. But that you suggested that your political communication throughout all of your political communication was potentially impacted. But I'm just I'm asking whether is that really the case in terms of what you do for 3 years and 6 months. You essentially can campaign as long reasonably okay on your issues.
Yes.
Without having to, you're not constrained in that time.
I think there's a difference there. I think the difference lies in that prior to the election being called, what you are doing is running a campaign either technically against the incumbent because they're not carrying the position that you need for your membership. Once an election is called and the parties or independents state their position on your issue, we then need to be able to educate our members, and because of the work we do, the community, about those political parties' stances on those campaigns. And so the ability to do that in the lead up to the election, under the existing cap, which we are in support of being changed to the 225, would effectively mean that we have to go quiet at the time that we could be most effective for our members' interests.
Thank you, Mr. Waits. Mr. Borzak.
Thank you. Yeah, that's an interesting point that you make, especially with so many independents in the parliament now. You're saying that you would differentiate their position in relation to campaigns that you would be running in their electorates, and that therefore you do need the higher cap to be able to have that choice of spending in those electorates. Is that what you're saying?
Yeah, if I can give you an example of our most recent campaign, our position was to support the candidates that support ratios. And our offer to each and every single candidate in each and every electorate was that if they committed to supporting ratios in the upcoming government, we would have members appear in photographs with them, support them on the campaign trail, encourage people to vote for those candidates. It saw our members in some electorates recommending a vote for either the Labor or the Greens or the Independents, depending on which. And even in one seat, supporting a member of the coalition because of their individual stance on ratios. So we won the campaign-based approach, supporting whichever politician supported our members' claim.
Does the same apply in the upper house?
Correct. We didn't differentiate between whether or not it was upper or lower house candidates. We made that offer to people.
Can I just say something? The PSA wrote to every single party and every independent person running in the upper and lower houses. We put that information on our website. It is still there. You can go and see it. There was one particular party that did not respond. Everyone else responded. So we gave that information to our membership.
Well, Ms. Ledig, who was that?
It was the Liberal and the National Party did not respond.
So there were two parties that didn't
Sorry,
respond.
two parties, beg your pardon. Yes. So everyone else responded except for one independent, and it was, I think her name's Helen Dalton. Is it?
Member for Murray?
Yes, she
Helen
didn't
Dalton?
respond, but she spoke to us over the phone.
Okay.
And
she
she
can't
said,
write then, is that what you're saying?
well,
Order.
she
Sorry,
didn't.
order.
But, yeah.
Order.
But we did give every party an opportunity to address the issues that our members had, that we actually surveyed, and what were the key points for them in regards to the election. So we have that information, it's quite clear. When it comes to the cap, we absolutely don't agree with having a cap, but we also have procedures and policies internally that we are guided by our council on what we can spend and what we can't spend and where we can spend that. We are a union and we are really careful with how we spend our money. So we are always going to give that information to our membership.
So just to further this point a little bit more, my coalition colleagues asked you, and maybe we'll start with you, Mr. Waits, about the level of your third-party campaign expenditure, implication being that it's all too high. Don't you think it's too high? And I don't think you actually answered that question directly, but anyway, that doesn't matter. Would you anticipate spending the same or similar amounts at the next state election or the next by-election?
Yeah, and I apologise if my answer wasn't clear. I don't think that the amount we spent previously was unreasonable. It is what is required given the cost of running such campaigns when we are trying to influence the public. Running a media campaign is an expensive exercise. Whilst, you know, we would love it if there were, you know, those ads came, you know, free of cost, then that would be fantastic, but that's not the reality that we're in. What we need to be able to do is run an effective campaign, and that's why we welcome the amendment to this bill, because we think that that's a reasonable figure that will allow us to run an effective campaign in an electorate.
So you also obviously then believe that your members should be deciding where their money is spent, not the government.
Our members absolutely decide where our money is spent. We put to them campaign plans. We first of all, our campaigns are based on our members' ambitions as put to us at our annual conference, which I've left today in order to attend this inquiry. Once those ambitions are set by our members, our council, which consists of members elected by the members, endorse the expenditure that we make. So, yes, I think our members, they rightly have a say in how much money we spend.
Thank you.
I'm open for the government saying that there's a cap, but the cap needs to be reasonable.
And Mr Bradshaw, would you like to address the same question?
I just, in addition to my colleagues' comments, I think our members would not only expect, they would demand, if their interests had not been taken up by whatever government is in place in the day. So, you know, like I said, our members vote for a wide variety of political parties. They're not Labor voters, they're National voters, they're Liberal voters, they're independent voters, shooters, fishers and farmers, you know, a wide variety. Shouldn't waste time naming them all. It is the issues that matter, and if, you know, this government doesn't take action on the issues that they said they would going into the election, then our members would demand us to spend the same amount of money.
Okay, well maybe you've answered this already, but so who do you actually campaign for at any one time in any election?
Our members.
The interests of our members.
Thank you.
Thank you, Mr Borzak. Questions now from...
I had one more, come on.
All right, I'll allow one more. Is it a good one?
It's always good.
All right, well, one more from Mr Borzak.
All right, well then, as an addendum to that, obviously, and it's a simple one, then you're obviously saying that you message for your members exclusively. Is that what you're saying?
Correct.
You're not messaging for a political party, of any party? You've just said that. Okay, thank you.
That was a good one.
That was a good one.
Yeah.
Thank you, Mr Borzak. Questions from the government?
Thank
Mr
you.
Nanvar.
Thank you, Chair. Mr Waits, the last witness provided evidence that the by-election campaign cost guides that the Nurse and Midwife Association presented to the Joint Standing Committee on Electoral Matters was flawed. Now, you may wish to take this on notice, but do you have anything that you'd want to say in response to that?
We would, of course, welcome any scrutiny of what our expenditure is, and that's done by the proper regulatory authority. You'd have to explain why they thought it was flawed for me to be able to respond.
So your cost guide was relevant within the context of providing some factual basis around the setting of parameters for caps, ostensibly 75% of a candidate's cap within a by-election. And your association provided some evidence around what it would typically cost to run a Metro by-election campaign, which I understand to be $190,000.
Yeah, I'll respond to that. I think the previous witness was suggesting that in a by-election you wouldn't use TV advertising. I don't know on what basis he would suggest that, because I don't think it's out of the question, particularly if there's a number of electorates. So I think these are reasonable estimates, and I would also point out that these are media spend, and we didn't include the cost of staffing in these estimates, and that is not insignificant. So I would refute his position.
Thank you. Just coming to the nature of the association's campaign, so Mr. Bradshaw and Mr. Waits, would it be a fair characterisation to say that they're better described as advocating for the industrial interests of your members and your sectors more broadly, rather than advocating for a political party?
Absolutely. Again, I'd just repeat from earlier. It's we campaign on our members' interests. They come from motions, from annual conferences, from workplace groups, from a variety of representative structures. And as I've said, we're not affiliated to any political party, and we represent the interests of our members.
Yeah, agreed. The campaign that we have been running now for over the last 10 years at least has been our ratios campaign, which is obviously to the benefit of our members to have improved and sustainable workloads. But after 20 years of peer-reviewed academic evidence, is demonstrably better for the patients of New South Wales, and in fact better for the budget line of New South Wales. So it is a good example of a campaign that is in the industrial interests of our members and to the benefit of the people of New South Wales who access the services our members provide.
Now, despite repeated decisions in the High Court with respect to unnecessarily restricting the implied freedom of political communication, we still keep coming back to this notion of acting in concert and prohibitions around acting in concert. What do you believe are the reasons the Liberal and National parties may seek to relitigate these arguments?
Well, I think it is an attempt to circumvent our freedom of association. I think that there are practical issues with acting in concert provisions, but I think there are also more deeper issues about that. I mean, at the end of the day, we're a union and we work collectively, and that's why our members join, is because they want to be with their colleagues that strength in that collectivity. Now, I mean, some of the problematic issues that come out is, and just one example is within TAFE, we have members within TAFE, the support staff, and the Teachers Federation, different union, they have members that are obviously teachers in TAFE. We have a campaign called Rebuild Our TAFE, and Teachers Federation have Rebuild with TAFE. Now, if it makes sense for the members of two different unions on one work site to collectively work together for an issue that is effectively the same, which is, rebuilding TAFE. But when we run into time frames and collective caps, I mean, we have no say over what the Teachers Federation spend their money on, and they have no say on what the Public Service Association would spend members' money on. That comes through our central councils. But effectively acting in concert provisions lumps us all together into the sort of one area for the purposes of reporting that money. So having joint meetings, down to simply having a local forum with other unions invited, paying for sandwiches, paying for catering. I mean, it all comes to the cap. So I think there are some practical problems with acting in concerts in terms of drawing the lines and putting those lines in place.
Mr. Waits?
I think my colleague answered that question well. For us, it is that question of the right for collective action. I can't speak as to why the Liberal National Party might be so concerned about us acting in concert.
Mr. Lawrence.
Thanks, Chair. So there's been a submission from the Liberal Party to the effect that the cap applicable to third parties should be a very small proportion of that the candidates have. and I just want to ask a few questions about that. Would you agree that a candidate, particularly a candidate for a major party, has a virtually immediate platform in an election campaign? Mr. Bradshaw first, perhaps.
Yes, I agree. A candidate has that platform granted.
Yep. And that's not a platform that you, as an association, enjoy in any given election campaign?
No, not a immediate platform. No, we have to spend significant amounts of money to be seen and heard.
Yeah, and you'd agree that the major parties, particularly, have a very well-established brand out there in the Australian community.
Absolutely.
And you'd agree that the mainstream media virtually automatically goes to major party candidates to get comment on specific election issues.
Yes. I mean, do you have anything to add?
Oh, absolutely.
Specifically, because
Yeah.
that's your.
Yeah, no, they do.
Yeah.
We have to build a campaign around what we are actually campaigning about. So
Yeah.
our last election, our members wanted them to campaign around privatisation. We wanted to stop privatisation.
Yeah.
We have to educate the community that we are going to in regards to that issue, whereas the parties already established themselves in their communities. Absolutely.
Yeah, but Mr. Bradshaw, would you agree that it's an important part of our Australian democratic system that organisations and citizens are able to influence other citizens and organisations in terms of their voting, for example?
I do agree. It is a fundamental right of democracy for us to put our speech for free speech and to put our views out there with the goal behind of educating other people in the community and trying to seek their agreement on those issues.
So would you agree with the proposition that there's some sort of inherent hierarchy where the voice of a candidate should be preeminent in the contest of ideas that is an election campaign?
Well, I think the election campaign is about that candidate, obviously, for those. That's the choice for the public. Assigning a hierarchy, I'm not really willing to wade into that. But I think that it's part. The whole system of democracy is hearing voices. That's our parliament from wide views and different opinions, and I think that's why I have put in our that's why in our submission we don't think that restrictions enable those views to be effectively out there.
So would you agree that in an election contest one can't automatically assume that the voice of a candidate is more important, for example, than what some other person might say about the candidate?
Absolutely, I agree with that, yes.
Thanks, Jen.
Thank you. Mr. Primrose?
No, I think it's the comments that have been made by the witnesses have satisfied me. Thank you.
Thank you. Well, thank you very much. That concludes the questions. Thank you very much for your evidence today. We appreciate you attending and also the submission from the PSA. I think there was a question or two on notice, and if we could have those back in the next 48 hours, the responses to those, that'd be very much appreciated. Again, thank you for your attendance and thank you for your contributions today.
Thank you.
Members, we'll have a break now and we'll reconvene at 2:30. Thank you. Time being 2:30, I will reconvene the Portfolio Committee number 1 inquiry into the Electoral Funding Amendment Bill 2023. And I'd like to begin by welcoming our new witnesses. And could I ask, starting on my left, that each witness provide their name and title, and then either swear the oath or affirmation.
Yeah, my name is Professor Annika Gallia. I'm a Professor of Politics at the University of Sydney, and I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you, Professor.
My name is Geoffrey Watson. I'm a Director of the Centre for Public Integrity and a Director of the Accountability Roundtable. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you, Mr. Watson.
My name is Kevin Rizzoli. I'm a member of the Accountability Roundtable. I've been since its inauguration many years ago. And I swear that the evidence now about to be given by me should be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you, Mr. Rizzoli. Now, do any or all of you wish to make a preliminary submission, oral submission?
I wish to make a very brief one.
Thank you. Mr. Watson.
This committee may know that for some time now, the Centre for Public Integrity has held up the New South Wales scheme as the best in Australia on the issue of donation and spending caps. In summary, at the Centre and also at the Accountability Roundtable, we believe that the proposed amendment is a reasonable and balanced adjustment to that scheme. No scheme placing donor caps and maybe especially spending caps on parties and candidates will either be effective or fair unless similar caps are placed upon third-party campaigners. This amendment is an essential component in making the current scheme more effective and more fair. I have read the JSCEM report and the justification for its proposals, including those which were noted but not adopted. I've also read the justification for the quantification of the sums. I've been researching in this area for some years now, and I believe that the approach taken by JSCEM was valid and the result is a fair and reasonable one, based not only upon theory but also upon practice. I read those parts of the JSCEM report which suggested that the reform should go further, combining spending from similar organisations. But I believe that that should wait. It should wait for two reasons. One, it could present a constitutional validity issue. And the second is, it should await some experience. And the last thing I'd say in terms of an opening statement is this. This is such an important issue, so fundamental to our democracy. An election funding act should be regarded in the same way that we regard a taxing act. That is, it should be under constant surveillance as to where it's working and as to where it's going wrong. You are lucky, we are lucky in New South Wales to have one of the most outstanding organisations of its kind in Australia, the New South Wales Electoral Commission. And I would urge the members of this committee to also consider that the matters which we talk about in this inquiry be remitted and referred to the Electoral Commission for their comment and observations once some experience of their effect is felt. Thank you.
Thank you, Mr. Watson. Mr. Rizzoli.
I'd just like to make a short comment that you spelt my name wrong. But anyway, it's only one L, not two L's.
Well, apologies, Mr. Rizzoli.
That's all right.
Apologies.
I'd just like to correct the record.
We're getting a replacement as as we speak. Very important. We'll now turn to questions from the opposition. Mr. Rath.
Thank you. My question probably to start with is to you, Professor, about some of the papers you've written on third parties as electoral actors and on third-party campaigning and issue advertising in Australia. Will you be able to walk through some of your research in those papers?
Yeah, absolutely. Thank you for the question, Mr. Ruff. I've been researching politics and elections in Australia for almost two decades now, and worked with the Parliament previously on earlier iterations of the Electoral Funding Bill and the Expert Committee in particular. And the research I've done has looked at the significance of third parties as electoral participants in Australian politics over time, that significance of which has certainly been increasing over the decades. And I have argued previously and on the basis of my research that third parties constitute important and significant democratic actors, but by virtue of that, they ought to also be regulated as electoral participants. So, as we know in New South Wales, that has been the case. The degree of regulation has changed over time in concert with the decisions of the High Court of Australia. But the fundamental takeaway from my research is that we cannot ignore third parties as electoral actors. They should be subject to donations and expenditure caps as political parties and candidates are in elections. So I certainly support the amendments suggested in the bill.
And should third parties be entitled to an equal or greater ability to persuade voters than a candidate or a party?
Yeah, that's a really interesting question. I think that the balance and the rationale that the committee proposed of around 75% of the cap for candidates and political parties is sound, and that also echoes the reasoning of the High Court that third parties, while they engage in electoral politics, they engage in a different way to the majority of political parties. I'm not going to say all political parties, but political parties are referred to as broad churches. They're actors that need to respond to a variety of different issues in the electorate. Third-party campaigners typically tend to be more specialised in their contributions to campaigns. So I would suggest that conceptualising their regulation and justifying their regulation relative to parties and candidates is an appropriate measure, but it certainly does not need to be at the level of parties and candidates.
And probably this is more to all three, but the Joint Standing Committee on Electoral Matters report that Mr. Watson referred to did make multiple recommendations, of which one was about the cap for third parties in by-elections. It only looked at by-elections, it didn't look at general elections. So any thoughts on general elections are separate to by-elections, but also from those recommendations, multiple recommendations were regarding the in-concert provisions and the potential collusion between third-party campaigners. So any thoughts on the in-concert provisions as recommended by JSCM?
I'm happy to go first. The actual idea of looking at third-party campaigners combining their interests and thus getting a greater say in the election is a genuine problem, properly examined by JSCM, but in my view it is wise at this stage just to do it step by careful step. The idea of combining interests, for example, two different trade union organisations or two different employer organisations, or, new player in the game, two different environmental organisations. Quite often they would bristle at the idea that they have identical interests even though they do overlap. So this stage I would just be anxious about finding out what the full limits of unions, New South Wales combined with Macloy, etc., about the constitutional validity of such a step.
Just to follow up, Mr. Watson, you said that in your view that two trade unions may have overlapping interests, but there must be not collusion, but there must be some working together when they are affiliates of Unions New South Wales, who then basically back in the Australian Labor Party. And we've heard earlier today that in history there are third-party campaigners and most likely New South Wales unions who in history have probably never ever supported any major political party as a third-party campaigner other than the Labor Party.
Well, that's true, and I agree, and I think Jay Skem pointed up the potential problem rather effectively. What I'm suggesting to you now is that this amendment is very effective. I noted, just like the Parliament, I suppose it was the Executive noted, the other recommendations of the Jay Skem before putting forward this bill. The point is that it's a genuine problem and it's got to be monitored. As I said, we've got an outstanding organisation, and I'd be going to the Electoral Commission each time an opportunity arises, whether it's by-election or a general election, to verify and check on what they think is the right result.
If your evidence is, Mr. Watson, that go step by careful step, do you think that the cap, as proposed by the government in this bill, this amendment bill, should be lowered, and if it still is not working, to be reviewed in time in consultation with the Electoral Commission? Like, do you think that there is a problem that this cap is too big too quickly from where it originated?
You want my personal opinion on that?
Well,
I'm
by
speaking personally.
Also the professor
yes,
probably would love your opinion.
I personally think that the sums advanced are too large, but that's very much a personal matter, and reasonable minds might differ on that. And also, it is something that's to be considered an overall scheme, judged by reference to the union's cases and McCloy, as to whether or not it meets the fair and reasonable balance.
So
but I would generally speaking agree.
So Professor, Mr. Rizzoli, like in terms of the cap as proposed in this bill that we're obviously having this hearing on, if we're to go step by careful step, don't we think that we're probably gone a step too far in having a third-party campaigners cap that is disproportionate to a political party that is actually putting forward the candidate on the ballot paper that the people in that electoral district or state will vote for?
Well, I think the size of the change in the cap, the degree, has probably generated a external issue to the actual question of the amount itself. And what I'd like to point out right from the beginning is that there is a great difference between campaigning for an individual person who is the representative of that electorate, or even in the case of the Legislative Council, someone across the state. But we don't really hear much about the campaign for the Legislative Council as such. We do hear something about it, but it's more concentrated in the public's mind on the individual electorates of the Legislative Assembly. So I think I was a bit surprised that the gap between what it was and what it's come to was as large as it was, but I'm happy to accept that that's worthwhile. I would like to see introduced into the bill an amendment which mandates a review of the effectiveness and the probity of the use of the electoral funds under the electoral cap after the first election in which it is used, rather than just leave it to common sense that yes, you'll review it as time goes on. I think there should be a particular examination of its performance under the first election syndrome, and I think that it has awakened a element in the community of third-party campaigners about getting funds to campaign that is not particularly healthy in one sense, but we must remember that in the individual assembly electorates, people are generally voting for a person, and that person is expected to represent a whole range of issues, and that is those capacity to represent the electorate on a whole range of issues is a different situation to someone who is just concentrating on a single issue and might, by the sheer weight of their electoral funding...
But would you agree, Mr. Rizzoli and Professor, maybe if you wanted to jump in, that if you had multiple third-party campaigners, whether they're trade unionists or not, or organisations, that are trying to determine an election outcome in a particular or multiple or all 93 electoral districts, it may become less about the person and more about the campaign when the actual independent or the actual political candidate or political party themselves, their voices become drowned out as the person who has their name on the ballot paper by multiple third-party campaigners that essentially can pool their resources together to push for a political agenda or outcome.
Well, I think there's a danger of that, and rather a sense of deja vu for me personally, because when I was first elected to Parliament in 1973 on the by-election, I had a very forceful campaign run against me by the Teachers Federation. And not that it made any difference, I still got elected, but I think my
Must have been a good
capacity to win the
He
seat
was.
on a larger margin was certainly pulled back by that very fierce campaign they ran. And that was not against me personally, it was just against a particular section of the responsibility of the government of the day. And that's where this interesting challenge comes in, and where I think once it's had one election in trial, it should be reviewed to see whether there is any evidence of distortion in the capacity of the electorate to choose its own candidate to represent it in Parliament, as distinct from representing an issue which, no matter how important it is, and I've campaigned myself on, well, I'm a great environmentalist and I've campaigned on environmental issues all my political life, but that has got to be taken into balance with the responsibility you have to each individual in that electorate that you represent, to represent their views, irrespective of whether you agree with them or not.
Just on the bill itself, so obviously with the JSCAM recommendations, of which there are multiple, the bill is looking in a way at one of the recommendations rather than all of the recommendations in the report. If you increase the cap from about $20,000 to $220,000 for third-party campaigners per electorate, but don't put in the in-concert provision at the same time, then essentially you could have a scenario where, come a by-election in the not-too-distant future, that particular electorate could be flooded with money, flooded with campaign expenditure. Every campaign, every third-party campaigner in a sort of US-style super PAC system could all be working together at $220,000 per third-party campaigner per electorate, which could amount to millions and millions of dollars in a by-election. I mean, isn't the more reasonable thing to do is to implement all of the JSCAM recommendations rather than just increasing the cap from 20,000 to 220,000, which could lead to potential unintended consequences of that quantum of money being spent?
Well, but is there a capacity to say, in case of a by-election, that the amount of money that could be spent by third-party campaigners, irrespective of whether they're all campaigning on the one issue or not, but the amount of money that is spent by third-party campaigners collectively is restricted to the amount that would be allotted to that particular electorate? So they would only have a much smaller pool of money than they would otherwise
And you see
have.
examples of this. I mean, in Western Australia, for instance, former National Party leader lost his seat after the mining industry spent $5 million in one electorate. I mean, surely it's not a good thing for democracy in a single electorate. I'm not talking statewide.
Gets rid of.
By having a cap, yeah. Well, I think we all agree on a cap. It's more the appropriate level of the cap and whether multiple third-party campaigners should be able to coordinate to, to essentially go beyond the cap. If they're each spending $220,000 each in a coordinated fashion, then it's not just a once-off 220, it multiplies and compounds to potentially millions of dollars like you would see in other jurisdictions.
Or is this cap as proposed, and this is a direct question, is this cap as proposed? Do you believe it is too high? Is it too high, too disproportionate to where we started from, and is it too disproportionate to what a political party that actually fields candidates on ballot papers can spend? Professor.
Look, I would say internationally, the proposed cap is generous. In jurisdictions like Canada, New Zealand, United Kingdom, historically, that ratio has hovered around 10 to 1. Similar as it is in the general cap for third parties. So I would describe the cap as generous. I think that there are two things to take into consideration there. I really do not see in terms of political practice that actually meeting the cap as it's proposed would be a great likelihood for the vast majority of third-party organisations, third-party campaigners that simply don't have these sort of resources that a few potentially might. So in practice, what I'm trying to say is that I think that you need to work both with the actual figures and the expenditure and gather that data, but you also need to have a sort of a theoretical benchmark as against the parties and the candidates. And the question is whether 75% is too much, whether something like 50% might be a bit more reasonable. Certainly, the High Court determined that 20,000 was absolutely nowhere near enough, so we can't go down to anything like 10%. I think that's a matter for understanding the differences between third-party campaigners and political parties and how they actually go about campaigning in elections. The problem with the in-concert provision, I think there's a few which make me sort of hesitant about it as well in how it would be seen by the courts if it was successfully litigated, is exactly how do you determine what is in-concert behaviour? How can you differentiate the activities of a number of like-minded third-party campaigners that just happen to reflect a groundswell of support on a particular issue from a coordinated effort on the parts of those third parties? So I think that sort of evidentiary burden is going to be very difficult to meet. I think the ways in which third parties operate in practice, they're a diffuse group. They're not particularly coordinated. They hold diverse views. Often it's, campaigns are run with under a shoestring with limited staff. So sort of the issue of being able to run a concerted, coordinated effort, I see it's always a possibility, yes, always theoretically, but in practice, I don't see it as a potentially high risk. I mean, the third thing I wanted to also raise with that point is that I do agree that there is an inverse relationship between the size of the cap and the necessity of having those in-concert provisions. The lower the cap, the less likely that any in-concert behaviour would have an impact.
Thank you.
Do any of the other witnesses want to make a contribution to that question, which I thought was a very important one?
I do, but only to say I endorse every single word the Professor said. I add only this. Mr Faraway, I agree that I personally felt that the caps were too high. I would not go so far as to say they were disproportionate. Slight difference, but it's a difference makes a big difference perhaps in a constitutional argument.
Thank you, Mr Watson. Questions? We don't have questions from the crossbench because some of them have left. Questions now from the government. Mr Nanva.
Thank you, Chair. Notwithstanding one's personal views with respect to the quantum of the cap, the critical point from my perspective is ensuring there is a cap in place that passes the constitutional threshold of the implied freedom of political communication. Having now had 2 attempts at this struck down by the High Court, a proposition has been put to this committee for a cap to be between 10 and 15% of an applicable cap for a candidate. In your view, does that get us back to the unreasonable burden argument?
That's Union New South Wales, number 1, and number 2, it fails. That's too low. The Professor dealt with this, I thought, eloquently. Sorry, I just stole your thunder there.
Sorry, Professor.
Yeah, no, I think I would say 75% is generous, 10% is not going to fly.
With respect to acting in concert provisions, Is the greater ill, from your perspective, from a public policy perspective, the fact that you can have independent third-party candidates with a commonality of interest campaigning on a single issue? Or is it that they may inadvertently or otherwise circumvent the spirit, if not the letter, of the caps and the law?
I think that anybody who suggests that the trade union movement is presenting through its many different emanations one argument has got rocks in their head. I've had practical experience of this. They have very diverse organisations with very different views. But I might add, I also know that's the same amongst the various environmental groups, where some of them regard the other as very conservative or very radical, and they're opposed to each other. So to put everybody into a kind of bag and say that because they tend to support one side of politics is really not fair, because this is a democratic voice. It might find its way of speaking is to favour the Labor Party. That's natural for the trade union movement, or for the environmental movement to favour the Greens, or for the employers' organisations, of which there are many who don't all see eye to eye. To say that, no, your voice is shut down because we're going to only accept that one of you can speak, that's wrong. And that offends the constitutional principle as well. That's why I've said that it should move slowly by slowly, bit by bit. Don't get it wrong. We don't want a union's number 3.
I think there's a question here about the actual definition of a third-party campaigner, because you can, you could lump almost everyone into the one basket of a third-party campaigner, and hypothetically direct all the money that can be collected by all those diverse groups into the one sort of attack force on whatever's the major issue facing the election. So I think that the question of what constitutes a third-party campaign, and therefore the people who represent that issue, what their role is in it, is important to look at. I don't know exactly what the answer is and how you would do it, but I think it needs some refined. It's just too broad a classification of a group of people in the community to be functionally operational. Yeah.
Yeah, I noted in the JSCAM report a sort of a concern with PACs, and that's already been raised here, and the Americanisation of Australian politics, potentially in New South Wales politics, in the establishment of these types of organisations. I don't see that happening. I know that looked like it could have been a concern maybe 5-10 years ago, but the way in which third-party campaigning has gone, and I look to the federal election as some evidence of this, is the trajectory still remains for the majority of groups. It's grassroots oriented. It's just the third parties themselves are distinctive political organisations in their own right. They are not established solely to promote the interests of a party or a candidate. In cases, and I think obviously Climate 200 is a really interesting case in point, and the intervention that was able to make in the federal election as a group, that didn't come through electoral expenditure, it came through donations to individual candidates' campaigns, which this legislation wouldn't capture. I mean, obviously there are donation caps, but something like Climate 200, these expenditure caps aren't going to sort of capture that particular phenomenon and the way that Climate 200 has operated. I mean, one of my suggestions would perhaps be, can we look at the legislation, can we look at the definition of an associated entity and think about how that potentially could be broadened to capture groups that are established for the purposes exclusively of supporting a candidate or a political party. I think that might be a way of providing some sort of a compromise for this concern with groups such as PACs.
Do you have a view on JSCAM's recommendation with respect to covering this space with respect to acting in concert if there is a deliberate intention to effectively circumvent the Act and the caps that are in place. So currently Section 144 makes it an offence.
Really important. I mean, just imagine if a single trade union split itself into 140 different packs. Of course, it's designed to capture that, and that's why this has got to remain constantly under supervision. And it's, by the way, one of the reasons why you have a J-scheme. It's joint and it's standing. You've got to keep it in mind. I'm sorry.
No, I think that is just so, the in-concert provisions are so difficult to substantiate.
And that's an appropriate resolution to...
I think it just would have to be extremely carefully drafted, and it would, I think, have to go beyond a third party's, I suppose, their campaigning in particular elections to go to the sort of substance of their existence and who they are. That's why I think that looking at it through a broader lens of associated entities might be a safer way of capturing that in-concert behaviour, because to my mind, like-minded groups would of course necessarily support the same candidate or the same political party, but it doesn't necessarily mean that they're acting in concert. It just means that there is another way of looking at it is a groundswell of political support for a party or a candidate.
Just one more question from me, if I could, just with respect to what you consider to be or should be the priority of this Parliament with respect to the problems in front of us. We are currently operating in New South Wales without a cap for by-elections. We are currently operating in New South Wales arguably without a cap for seat caps for general elections and for multiple by-elections on the same day, because arguably that will fail for the same reasons that the by-election cap has failed. From your perspective, should the priority of this Parliament be to put a cap in place immediately, regardless of the debate around quantum, and have JSCM do a constant review as to whether that cap is or isn't adequate?
Wholeheartedly, yes. But I'll add these words to it. A constitutionally valid control, which this would be, in my opinion.
And I would agree. I mean, a by-election could be called for whatever reason immediately. So I think that's a huge hole that needs to be filled immediately.
Sorry, Mr. Watson, you think it would be constitutionally valid?
As it presently stands, yes.
Thank you.
Mr. Primrose, I think you indicated...
I in fact was going to ask a very similar question, given the invalidity of Section 2911 in relation to caps for third-party campaigners for by-elections having been found to be invalid. What do you think would be the effect of that if we had a by-election in 3 weeks?
Originally, when I was sent a message to appear, I was going to appear with Anne Toomey and Nicholas Owens, who were constitutional experts.
Yeah.
Owens with particular experience in this particular area. Ask them, not me. But as I presently read it, I don't think there's any cap in place. I think that it's been ruled invalid.
Yes, it has.
And there's nothing. There's no control. And that's a glaring omission in a scheme like this.
So if this Parliament and its members chose to rule this bill out and vote against it, and we continue to have things as they are, having given the decision of the High Court, then that means that a by-election will be essentially a free-for-all without a cap.
I'm afraid so. That's the way that it looks.
That'd be a pretty courageous decision, I think, of anyone to
No one's
decide that.
suggesting
Okay.
No one's suggesting.
Do you have any other questions?
Yeah, just a couple if there's time.
Yes, absolutely. You've got 4 minutes and 3 seconds.
Use them all.
Yeah, I will. Professor, in terms of the question of what percentage of a cap should a third-party campaigner have as compared to a candidate, I just want to ask some questions about that. Would you agree that particularly candidates for major parties in our system have a significant advantage?
Yeah, I would agree. I mean, candidates of any political party have an advantage over independent candidates and third-party campaigners in terms of both material resources, but also just brand recognition. I think that's probably the main one.
Yeah. In terms of brand recognition and also, I suppose, the way that the mainstream media will interact with major party candidates, how do those two things come into consideration of what percentage the cap should be for a third-party campaigner? Like, they're at a disadvantage, would you agree?
Well, they do. They start off at a... So in terms of the brand... Well, some third-party campaigners, for example, well-known campaigners like Get Up, obviously their brand is well established, but not necessarily the cause that they're campaigning for. So parties do receive an advantage by virtue of that brand recognition. The other, I suppose, the disadvantage that political parties are also faced with is appealing to electors on a number of different issues. So rarely do you have parties that are purely single issue. I mean, if they're a single issue party, they have multiple agendas and multiple points of campaigning. So parties have got to cover more ground. Third parties are more bespoke, typically, in their campaigning efforts. So we can compare them in that way. What's also really changing, and this is a bigger point in this whole political finance debate, is the way in which campaigning occurs. I mean, so much of it is online now. Of course, that's still costly, but the big ticket spending around television advertising, radio advertising is being very quickly supplanted by targeted online advertising. One thing that COVID has taught us is that we have to pay attention to the importance of locality in elections as well. So, like, thinking about single seats in terms of campaigning and caps in single seats is really, really important as well. So,
Okay, thanks, Professor.
Could I just
Watson,
add to that?
Sure.
Because with only 4 minutes and 3 seconds, you asked the best questions of the day, quite frankly. The first one raises that question about the value of it's not just brand recognition, but the incumbency advantage. And the second question asks the allied point about what proportion does that reflect. That's what I went through the JSCM to try and find. No researcher knows the answer to those questions yet.
Yeah, because I'm really concerned that we're taking arguably a party-centric approach that entrenches a supremacy that could be concerning in the context of a very solidified two-party system.
That's what I was worried about when I read the whole thing.
Yeah. Mr. Watson, there's been a proposal put by the Liberal Party that an organisation that chooses to affiliate with a registered political party should not be permitted to register as a third-party campaigner. Is that a proposal, and I hate to seek free legal advice, but is that a proposal that you think would pass muster in the High Court in terms of burdening the implied freedom?
It's got a problem insofar as it's got an historical root which is not easily pulled apart from the entities. For example, the Australian Labor Party is an emanation of the trade union movement. So we're really going back to 1908 when we're talking about the practical effect of that. Now, the question about affiliation and the value of affiliation in terms of setting caps, that's been a vexed question at a federal level as well. And currently, some of the figures are too high, reflecting the advantage of affiliation. But by golly, that's difficult. And it's not purely the Labor Party's problem, because in some ways, other parties and parties which are not yet formed will come about in the same way that a group of like-minded people wanted to get a political voice.
Yeah, there's just one further question I wanted to ask, if I could leave the chair.
We'll just see if we've got time, because we just want
Sure.
to... And just before we go...
I'm happy to split the crossbench time 50-50 if you
Sure.
want to be fair. So
Okay, we'll go with your question now while
as
you...
long as it comes back to us.
Yeah.
as well.
So there's been a proposal put that if an organisation chooses to make a political donation to a registered political party, that they shouldn't be permitted to register as a third-party campaigner for 4 years. So effectively a prohibition on their engagement in the process. I appreciate that's a complex range of issues, but are you able to give us some sort of thoughts on how that might sit with the implied freedom?
Got to be a straightforward clog on the implied freedom. And true, you can justify that if the circumstances demand it. McCloy is hot evidence of that. But just to impose that as a blanket just seems to me to be shutting out potential voices who wish to be heard on a democratic issue. Something you can't do in Australia.
You can't mandate how people participate in politics. You know, if you can't say if you go and vote, we're not going to let you sign a petition, and that's sort of an analogy with what that proposal does.
Yeah.
Sorry, I have a question. What are your thoughts on the proposition that third-party campaigners who have to register be also required to declare or disclose that they are not acting in concert with other parties if they are afforded this, in your words, generous cap? Why should we not put more restrictions or disclosures on those third-party campaigners to make sure that they are operating as separate entities and not aggregating their efforts? What are your thoughts on that?
Well, I'll reverse my earlier ruling and say that's the best question of the day, and it's a really, really, really hard one. The point is that what you're talking about now is trying to discern what's the thinking of a particular organisation in advancing a particular political voice, and it's almost impossible. A lot of the charities complain when you propose caps and especially disclosure rules that the Smith family might say, well, look, we campaign on the issue of homelessness. That makes us a political player, therefore we've got to declare donations to the Smith family, and it's unfair. That's something you just need to work your way through when the practical instances arise. It's not easy. I've been sitting here and thinking about combining the interests of two organisations. I'm here for the Centre of Public Integrity and the Accountability Roundtable, and I can tell you that on occasions they've got quite different views. So if they were both regarded as third-party campaigners, they would resent being placed in the one bucket. What you're saying is a real issue and a real problem. Quite often, the party which is being asked to say whether or not they are supporting a position will say, well, to some extent, but not fully. So hard.
Thank you. Mr. Rupp.
Mr. Watson, are you concerned at all about, I suppose, when it comes to political donations and campaign expenditure, whether real or perceived, influencing ministerial decision-making?
Oh, of course.
And don't you think that that sort of political donations and campaign expenditure should be publicly declared and disclosed?
Sorry, I can tell you the Centre for Public Integrity and the Accountability Roundtable are 100% in favour of real-time disclosure. That sort of thing needs to be disclosed. That transparency it's our basic right as voters.
Above a certain threshold? Or
Yep, sure. You've got to set a threshold. The reason for that is just the sheer practicality of the burden cast upon the organisation, so that if they've got, for example, to go through it and make disclosures in respect of somebody donating literally $10, $20, $25, it costs more to make the disclosure than the benefit they're receiving under the donation. And we want people, by the way, people who can only afford $10, to be able to donate $10 to a political cause.
And are you aware of any recent examples
Of
like concerning donations that probably should be publicly declared?
Well, New South Wales is very good. It's $1,000, whereas federally we're $17,600.
We're going to real time.
Yeah. I suppose just probably a final question to all three is from us is, isn't the incentive though, when you do have a campaign expenditure at $220,000 per third-party campaigner, that political parties will look at it and think that that they need to get around the expenditure cap, which is they can essentially game it, that a political party looking at it would say to themselves, well, we've got a cap in a particular electorate, and our opponents have a cap in a particular electorate, so we need friendly third-party campaigners to help us obfuscate the cap. So they would either create new entities, friendly third-party campaigners, or go to find existing third-party campaigners to essentially help them campaign. And that might not necessarily be a particularly good thing, electorate by electorate, to essentially have political parties trying to get around the cap by drastically increasing the funds they spend by finding friendly third-party campaigners. Isn't that a concern? When it's only at $20,000, it's very different. It's almost not worth it compared to when it's a generous $220,000.
I couldn't agree more. I don't know whether you know my background, but I do know quite a bit about this.
Yeah, of course.
And the point is that, yes, that's a genuine problem, but how do you handle it? You only handle it with the catch-all provision, which is in the legislation, which allows the Electoral Commission to act where they think that kind of conduct is occurring.
Thank you very much.
Sorry.
Thank you very
I'd just
Mr.
like to
Rizzoli, yes.
respond just very simply and say, as soon as you bring more money into the equation, you bring out the worst in human nature. Simple as that.
Well, that's a fitting finale to the contribution, and couldn't agree more. Thank you very much for your evidence today. We appreciate the fact that this occurred in a very short time frame. So thank you very much. I don't think there are any questions on notice. No, and so thank you very much, Professor and Mr. Watson and Mr. Rizzoli. Thank you for attending and contributing today.
Thank you.
Thank you.
Thank you. Thank you.
A regular program.
Okay.
You're going to tempt me to stay now, Jezza.
Okay, thank you very much for attending the inquiry by the Portfolio Committee number 1 into the Electoral Funding Amendment Bill 2023. Could I ask, starting on my left, that you state your name, title and swear the oath or affirmation, please?
Yes, Rachel McCallum, I'm Executive Director, Funding Disclosure and Compliance in the General Counsel at the Electoral Commission. And I'll take the affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
Hugo Bergeron, Director of Compliance. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Do you have a short opening oral submission to make?
No, we'll just take questions, thank you.
Okay, great. Thank you very much. We'll start with the opposition.
Thank you for appearing today. Am I correct in understanding that an organisation can donate to a major political party and an affiliate, and then also as a third-party campaigner? So essentially, any entity as a third-party campaigner, they can do essentially be politically involved in 3 different ways. One is as a direct donation to a political party, one is as an affiliation fee, and then the third way would be also as a third-party campaigner.
I'll just note that the affiliation fee are also political donations, so they're subject to the same disclosure requirement.
So they're viewed as political donations,
yes,
essentially.
There is an exemption in relation to the cap. So the affiliation fee, for example, for a union, for lack of a better word, is limited to a certain amount per member.
Yeah.
But apart from that, it's required to be disclosed the same as a political donation.
So an individual on the electoral roll, we can give, I think, about $7,000, is it? A business or an organisation, any type of organisation, they can give about the same, around $7,000. But then affiliation fees to a political party are considered completely separately to that. Is there a cap on them?
Yes, it's $2,000, I think, per members. There's a restriction on the use of that fund, so that those affiliation fee cannot be paid in the state or local government campaign account of a party, which means that it can only really be used for administration purposes.
$2,000 per member in that organisation?
That's it.
So if they've got 100,000 members, so it could be like potentially a lot of money per organisation, depending how large that organisation is. So essentially you can be a third-party campaigner, but also affiliated to a political party. I mean, doesn't that just feel a bit like double tipping in a way? Yeah, no, you don't need to answer that. You don't need to answer that. In terms of the affiliation fees that are paid to political parties, how do you monitor that money isn't being used for political expenditure?
So we conduct routine compliance audits of disclosure, and that includes a review of the campaign accounts of registered political party, and we make sure that the types of funds that cannot be paid in a campaign account are indeed not paid in that campaign account.
So I suppose to understand what sort of things could the money be used for, the affiliation fee money be used for versus a direct donation under the $7,000 cap, like political advertising obviously goes to the campaign account. If it goes to the admin account, could that be things like rent for the office space, the staff costs? I don't know, what's some sort of examples in each bucket, if I can put it that way?
I guess the best example would be what you'd find under Section 84, which is define what administrative expenditure is, and that's exactly that. So expenditure on staff, expenditure on developing policies, expenditure on rent, some research as well could be included in that.
Do you know, and I appreciate you might have to take this on notice, but in terms of third-party expenditure, do you know what proportion of third-party campaign expenditure is undertaken by trade unions versus all non-trade union entities?
So it would vary from election to election. I do have the list of expenditure for the last round of the 4 by-elections that were held in February 2022, so I can easily table that.
Okay, that would be great. I know we're still waiting on the 2023 general election, and you probably would have the 2019 state election.
Yeah, well, all of those disclosures are available online, but we can certainly put that together.
Okay, all right. Yeah, no, I think the proportions would be good to know. Do you think
so? You're going to sorry, just to be clear, you're going to table the 2022 and the 2019. Is that what you've asked for, Mr. Rudd?
Yes.
2022 I have with me now. 2019 I'll have to answer that on.
Okay, that would be great.
Thank
Thanks.
you.
Do you think there's a need to tighten reporting requirements or the reporting time frame surrounding third-party campaign expenditure?
What do you mean by tighten?
Either reported in a more timely fashion or more audits or checks as to what the expenditure was going towards.
I mean, the reporting time frame are the same as other political participants in relation to the expenditure incurred. In relation to the, as I mentioned, routine compliance audit that we undertake on all political participants, this is based on a risk-based approach. I think one of the main risks, obviously, is we see the amount of campaign that's being done on the ground, and depending on what the cap is, we're able to kind of assess whether a certain third-party campaigner might have a higher risk of having exceeded the cap, and we might do a bit more work on those.
Yeah.
And obviously we have some that a lot of third-party campaigner would register for an election but never actually spend money and never campaign, sometimes just a preemptive in case they want to campaign at the last minute. So we do take all of that into account, define the audit procedure that we perform on those disclosures and those third-party campaigners.
Probably one thing I'm a little bit confused about is with third-party campaign expenditure, the statewide figure versus the local electorate figure, and then also how that relates to the Legislative Council. So there is a cap, a statewide cap for third-party campaigners, which every third-party campaigner has to meet, but then there's also an electorate-specific cap that they can't go beyond either. So they have to meet both requirements. But how does that relate to the Legislative Council? Like what is the cap for the Legislative Council campaigning for third-party campaigners?
Not sure I understand your question.
Are you asking about a campaign that's been run on a statewide basis by a third-party campaigner versus a specific district?
Yes.
Campaign?
Yeah. Essentially, that say you're a third party, this doesn't matter if it's a industry association or a union or whatever, you can only spend a certain amount of money per electorate, but then you have a statewide cap as well. But is the statewide cap the same as like the Legislative Council cap? Or is it that there's a Legislative Assembly statewide cap for all 93 electorates, of which you can only spend a certain amount per one electorate, but then there's a separate Legislative Council cap as well, if that makes sense?
I think.
I might just try to answer. So those two caps, so the overall cap and the individual district cap, are applied independently. So if I'm spending money on expenditure targeted for one specific district, that money will be counted towards both the district cap and the overall cap. So we're limited in the total amount, but within that total amount that we spent, we're also limited into the money we spend, a third-party campaigner of the party would be spending in relation to a specific district.
But then is there another additional legislative council cap? No.
No.
So if
No,
a
that's
third
not
party,
how we've taken
yeah,
it,
no, that's
sorry.
basically
Yep.
what I was
No,
asking.
It's not an extra billion.
An extra, so you don't get there's not like two caps. It's not a double. Yeah, I wasn't just sure when I was looking
Sure.
through the
No, okay.
legislation before how that would actually work in practice. But that makes sense. Yeah.
A question for either, representing the Electoral Commission, is in regard to the Legislative Assembly, you have a electorate district cap and you have a party cap for political campaigns currently. Now, I can't remember the exact figure, but I think it's up to $250,000 if you combine both, the party cap and the electoral district cap for either the Liberal Party, National Party, Labor Party, Greens, legalise cannabis, whoever it is, to spend. Do you believe that having a third-party campaign cap in an electoral district, of whichever one of the 93 or all 93, that is equivalent to almost the total of what a political party can spend who actually fields the candidate? Do you think that that is disproportionate, that what is being put forward in this bill?
I think that's a question of policy for the Parliament and the government to consider. I think that we don't express a view on the appropriate level of the caps. We are happy to talk about what the expenditure has been under whatever the legislated caps are, but we probably wouldn't express a view about what the cap should be, because those types of issues raise policy and constitutional questions that it wouldn't be appropriate for the Electoral Commission to express a view about.
Thank you, Mr McCullum. I'll now turn to questions from the government.
Thank you, Chair. What is the Commission's understanding of the ramifications of both Union's New South Wales High Court challenges?
The ramifications, as in why we're having the bill that the committee is looking at.
What has ultimately been the outcome of the Union's New South Wales challenges?
Well, I think that's a very broad question.
It's a very broad question, Mr Namber. I mean, maybe you could skin it
is
down
it in connection with the bill or?
In connection to third-party caps in New South Wales?
Well, I think the ramifications are that we have a bill before the Parliament seeking to introduce another cap to reflect the High Court's decisions that the third-party campaigner caps, as previously provided for, were unconstitutional.
Do you have a view as to an adequate quantum that would pass the constitutional validity?
No, I don't have a view.
What is your understanding currently of the validity of Section 29(12) subsection B with respect to multiple by-elections on the one day and general elections, seat caps for multiple by-elections on one day and general elections?
So was your question that what is my view on the constitutional invalidity
on the
of those sections?
on the current status of that provision? So as I understand, Section 29(11) was the provision that was successfully challenged in the union's case. Would you have cause to believe, given there is a current cap of $20,000, or I don't have the exact figure, in 29(12)B, that would fail the constitutional threshold too?
Mr Namber, I think it wouldn't be appropriate for me to express a view about what may fail in a constitutional challenge.
May I ask, if I may, my understanding is that section's already been ruled invalid by the High Court, which would mean that at the moment there is no cap. So if we went to a by-election, there would be no cap. That's the case, isn't it?
Well, the additional cap, which is subsection 12, is still there, as far as I'm aware.
What the High Court would make of that in the context of its decisions in the union's matters. I don't think it would be appropriate, but it would be helpful as a regulator of electoral funding to have it clear in the legislation what caps applied for third-party campaigners in a by-election.
The Commission was consulted about the bill before it was presented? That's right, isn't it?
Yes, that's right.
Okay. I note that Parliamentary Council's editorial note after the section I've just mentioned states, on the 15th of February 2023, the High Court of Australia and Unions New South Wales against New South Wales 2023 declared that the cap imposed by section 2911 is invalid. So is there a cap or not?
Could I perhaps ask, were there a by-election next week in New South Wales? What would your advice be to third-party campaigners who are seeking to engage in the political debate?
That there is no cap.
Okay. That's what I'm seeking.
I think the distinction there I'm making is what would our advice be, or what would our guidance be to third-party campaigners versus saying what I thought about what the High Court might say about the matter.
Okay.
Putting to one side any legal policy and constitutional questions regarding the quantum, would you agree that the Act contemplates distinct caps for different political participants and different electoral contexts?
Yes.
With respect to Section 144 of the Act, if I can just turn to that, regarding it being an offence to enter into or carry out a scheme.
Yep.
There has been a proposition by the Joint Standing Committee that might be an appropriate way to manage concerns regarding different third parties pulling resources together in a manner that inadvertently or otherwise might circumvent the caps in the Act. Does the Commission agree with that observation and recommendation? So if third parties are intentionally looking to circumvent the caps in place for them individually, that provision would be enough to capture that conduct?
I think there are legal policy questions that are probably not... I can't answer your question exactly the way you framed it, but if what I could say in response is a circumvention offence is something that the Commission would need to consider after an investigation, and the timing of that action that we could take in response to allegations that such conduct had occurred would likely be well after an election event had occurred. So there are questions about whether or not what conduct the Act might be seeking to regulate, and how a regulator could best enforce that at a particular point in the election cycle. So whether that's enough, it depends upon what the policy problem you're trying to solve with the Act is. So so I can't say whether that's enough because I'm not quite sure what the policy issue would be, and frankly I wouldn't comment on the policy options that might be available. I would only say that whatever legislative response to those policy issues should be as clear as possible as to what role the Electoral Commission would play in relation to enforcing it. So what the elements of the offence might, if it was an offence, what are those elements? When does the conduct need to occur? Just rather than a broadly worded offence that would be more difficult to enforce.
I've got a follow-up question there. What are the requirements of third-party campaigners to register? There's an official agent. What other disclosures do third-party campaigners have to make? And are those disclosures robust enough and comprehensive enough to actually enforce the provision that Mr. Nanva was alluding to in his question?
Do you want to outline the registration?
Sure. So the registration, so a third-party campaigner is required to register and appoint an official agent before making payment for electoral expenditure. So at any point from the time they are a third-party campaigner, which is when they've incurred more than $2,000 of expenditure during the expenditure period. So that's the registration requirement. Registration ends essentially the Monday before the election, so someone cannot register in the last week before the election. In terms of disclosure, the disclosure is essentially broadly the same as a political party or a candidate. The only exception is in terms of disclosure of political donation. Only reportable political donation are required to be disclosed. Small political donation, even if they're used, and by small it's less than $1,000 in aggregate from the same donor, would not be required to disclose to be disclosed. In terms of electoral expenditure, they're required to disclose electoral expenditure at the same time.
And they have to register election material as well with the
for distribution on election day.
On election day.
It's only on election day, so it's a long-standing requirement that that's the only type of electoral material that gets registered.
Thank you for that. Are there any other questions from the opposition or the government? No. Well, I very much appreciate the Electoral Commission coming along to participate in today's inquiry. There may be some supplementary questions in writing to you, but and we've got a very short turnaround on those, but so that's highly unlikely. So thank you very much for your attendance.
Thank you.
Today.
Thank you.
Was there questions on notes?
The table for
the table.
2019.
So thank you very much. So if you get that 2019 information to us expeditiously, we'd appreciate it. So thank you very much for your attendance today.
Thank you.
Hey, Mr. Dignam. Welcome to the Portfolio Committee Number 1 Inquiry into Electoral Funding Amendment Bill. If you could state your full title, your name and full title, and swear the oath or affirmation, please.
Okay. Paul Dignam, I'm the Treasurer for New South Wales Greens. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Now, Mr. Dignam, we've only allocated 15 minutes because of the late appearance. So do you have a brief oral submission you'd like to make before we go to questions?
Yeah, just quickly, I think it's pretty well known that the Greens have always supported caps on electoral expenditure. The cap in this particular bill we would probably think is too high, but we also acknowledge that the fact that at the moment we don't have a cap is not a situation that we want to continue.
Great. That'll
be
the remarks. Okay, thank you. The questions from the opposition.
Thank you. Thanks for coming in. I don't think anyone's suggesting we shouldn't have a cap. I suppose that there is a proposal, obviously currently before the Parliament from the government on increasing the expenditure cap for third-party campaigners from around 20,000 to over 220,000. Obviously, through the parliamentary process, amendments can be made in either chamber, the upper house or lower house. What sort of level of campaign expenditure do you think would be appropriate?
Yeah, that's a good question. I would probably go for something around about, I'm trying to think. I think when we made a submission to the Joint Standing Committee, we suggested a general cap of 90,000, and then all other caps be proportional to that. Like that was 90,000 for an assembly thing. I suppose with inflation, you could probably call that about 100,000, and therefore, maybe around the 75,000 mark for a third party, as we think would probably be high enough to not be considered too low by the High Court, but proportional to what we think would be an appropriate cap. But that's, that's just a ballpark figure. We haven't arrived at.
And we are in
anything
this
definite.
really difficult position now where 20,000's too low.
Yeah.
220,000, some would contend, is too high.
Mm.
But if you go too low, you obviously don't want it to be struck out either.
Mm.
So where do you draw the line, I suppose, is the question. In terms of your organisation, in terms of the Greens, what sort of level of or quantum of donations do you receive from organisations? So not from individuals on the electoral roll, but from registered entities.
We don't accept donations from organisations, only from individuals.
Right, and you don't have any affiliated organisations that pay affiliation fees?
No.
And in terms of the third-party campaigners that exist today, or that registered for the 2023 election, were many of them helpful to the Greens, would you say?
That's a really interesting question. I think you'd have to be, honestly say that there would have had to be some that probably were campaigning on similar issues to us. It's quite possible even some of the union campaigns may have helped us where we had policies that aligned with what they were asking.
And obviously there's businesses, corporations, big businesses, and there's industry associations as well that are involved in third-party campaigning. It's not just trade unions; it's the whole range of different entities. So they're obviously subject to the same cap as well. They're all subject to the same. Are you saying that you think that if a candidate if they've got around $100,000 in campaign expenditure that they're allowed to spend, that it should be more like $75,000 for a third-party campaign, or is that the?
Yeah, we'd probably go for, I would imagine, around about a 75%, based on the idea that, a candidate is running, either as an independent or as a member of a party, but they still have to, be across a range of issues, particularly if they are a member of a party. They have to sort of represent both that electorate and also the policies of their party. And that's sort of a bigger job than a third party which is kind of generally running on an issue which is, very rarely are these issues electorate based. There might be some, but most of them would be statewide. So when you aggregate all of the money that they have to spend, I think they've got, at that level, have got quite enough to get their message across.
How do you think it would impact smaller parties? And I contend that the Greens are now probably not a minor party anymore, but a major minor party, if I can put it that way. How do you think it would impact minor parties and the Greens by increasing third-party campaigners from $20,000 to $220,000 per electorate.
Yeah, well, I think given especially that that's sort of like, you know, almost the same as the cap for the party itself, you know, it would probably have a more adverse effect on smaller parties who may only be running in, you know, a small number of electorates. It may have be less of a problem for the major parties, but and it would, I imagine, it would have a bit of an effect on us. But smaller parties than us, you know, that are just running a few candidates and maybe a few upper house candidates, I think they could very well be overwhelmed by that amount of spending. Those parties wouldn't likely be able to spend up to the cap anyway. They probably wouldn't even have the resources.
Yeah, thank you.
Thank you. Any questions from the government?
Just briefly.
Mr. Lawrence.
So the suggestion that smaller parties might be overwhelmed by third-party spend, that wouldn't be the case though, would it, if the third-party spend was actually in support of the aims of the minor party, would it?
Well, no, that would in fact, yeah, be a help. That's a fair point. So I guess it really it would depend on the party and who all the different third-party players were. I mean, it would probably be a different situation for every party.
Okay.
But yeah.
So would you agree that in our political system there's an entrenched advantage for the established parties?
Yeah, I think that there is. A lot of that just comes from loyalty, which isn't as strong as it used to be, but, you know, that's something that's probably quite separate from, you know, the amount of money they can raise and spend. But yes, that's changing. So, you know, but certainly, you know, the more established parties have just better resources for fundraising. And I think this is why we sort of think that having lower caps is better, because it's all very well to say, well, look, we'd like not to have a cap to be able to spend whatever we could, you know, as a third party thing. But I mean, you're going to find that you're going to run out of money one day, and there might be another third party with an opposing view that's just simply got more money to spend than you have. And then you put yourself in a bit of a disadvantaged position.
So would you agree that we've got essentially a two-party system in Australia in terms of the parties of government?
Not strictly. I mean, you know, it's still obviously that the two major parties, or the coalition and Labor, still, you know, have a dominance on the thing. But I think certainly we're getting bigger, and I think there are other, you know, parties that are smaller than us that are still maybe making an impact. But you know, it's still going to be a long time before we see any real breakdown of that.
Yeah, and would you agree that in the context of the Coalition and the Labor Party being the two main players, if I can put it that way, that there's a lot upon which those two groups agree?
There's probably a reasonable amount, yeah.
So do you think
there's obvious differences, of course, but I think there is a lot, yeah, where they do agree.
So do you think that factor and the advantage that established parties have means that it's actually quite important for third-party campaigners to be able to effectively campaign?
Oh yes, I wouldn't like to lower the cap to a point where they wouldn't be able to campaign at all. You know, but as I said before, I think because they can work across a particular issue across the broad electorate, as opposed to that, it's why we think that it shouldn't be as much as a political candidate. But yes, it shouldn't be set so low that it's basically of no use, which is pretty much what the High Court said, that a $20,000 cap may as well be nothing, you know, and may as well say you can't spend anything. Yeah.
And would you, I think you might have said this, that a 75% ratio seems about right to you?
Yeah, I think something
the
around
percentage
there,
that a third-party campaigner would have vis-a-vis a person who's standing as a candidate?
Yeah.
Okay, thank you, sir. Thanks, Chair.
Thank you, Mr. Lawrence. Well, that concludes the questions. Thank you very much, Mr. Dignam, for coming and putting the view of the Greens in New South Wales. We appreciate your evidence and the fact that this happened in quite a short period of time. So thank you very much for coming and appearing today.
Thank you.